Motion at serial number 60 for hearing motion. The land of the petitioner will also
We can't hear it. We are just on the verge of vacation right now.
if not today, tomorrow's
No,
will be given in that matter election.
You can have it only after vacation. This matter has been running in the list for quite some time. You never mentioned it.
There is a sudden urgency election.
No, it is not possible. You see, there are so many pending work, and then judgments are to be corrected. It is not possible. As it is tomorrow, the court is not available. Day after also, the court is not available. I am making it very, very clear to you. So therefore, it is not possible this side of the vacation. You can have it only after vacation.
From supplementary list for orders item 1, WPC 5501 of 2015.
सौरभ को बोले थे खबर करने के लिए कल परसों के लिए पता नहीं भेजे हैं कि नहीं.
लॉर्डशिप लास्ट ओकेजन में इसमें मिस्टर अभय प्रकाश का इंस्ट्रक्शन था क्लाइंट फाइल वापस लीजिए.
आज पिटिशनर कहाँ है? Where is the petitioner? Are you there in this case?
Let's see, he is on legs, but let's see. So
Who is on
short
legs?
pass over. Mr. Rahul Kumar Gupta.
So 12 o'clock?
Yes, sir. Okay.
Item 3, permission item 3 WPL 6414 of 2024.
Yes, petitioner.
We are aggrieved on Annexure 3 by order dated 16 July 2024. Relevant paragraph would be, Your Lordship, relevant page would be page 37 and 38. Page 37 and 38. Your Lordship, what facts of the case is that the respondent moved before the gratuity court for payment of gratuity. That was allowed in favor of the respondent. We were directed, the ECL were directed to pay rupees 14 lakh, Your Lordship. We have deposited that statutory amount before the gratuity court. Now, Your Lordship, we preferred an appeal under section 7, subsection 7. That has been rejected, Your Lordship. The grounds of rejection, Your Lordship, may kindly bear with page 37. May be permitted to read. Your Lordship, I heard this matter on the last occasion. On perusal of the memorandum of appeal filed by the appellant management, it has been observed that the order judgment of controlling authority dated 22/11/23 was sent to the appellant and the respondent by registered post on 23/11/23. And appellant has admitted that he had received the order of controlling authority on 30/11/2000. But just after receipt of the order of the controlling authority, they have taken necessary steps for approval from the competent authority for filing appeal, which took some time, so the delay occurred. However, they have filed the memorandum of appeal before the appellate authority on 27/5/2020.
It has been dismissed on account of delay.
Yes, Your Lordship. But Your Lordship, delay part, Your Lordship, our contention was, Your Lordship, that this is a government organization.
The law does not permit continuation of delay.
60 days time, Your Lordship.
30 plus 30.
Your Lordship, it was preferred after a lapse of 177 days, Your Lordship.
WPL number 6414 of 2024. For the learned counsel for the petitioner, district petition has been filed for the
The
following.
delay part may be taken care of and can be
The
remanded
learned
for
counsel for the
adjudication.
petitioner has submitted that the controlling authority had passed an order for payment of gratuity in favor of the wife of the ex-employee. The applicant was Srimati Javuna Devi, wife of late Vishwanath Bhuya. He submits that the specific case of the petitioner was that appointment of Vishwanath Bhuya was through impersonation. However, the petitioner filed appeal before the appellate authority, and the appellate authority has dismissed the appeal on ground of delay. He has submitted that considering the fact that the husband of the applicant obtained employment through impersonation, his appointment is null and void, and this aspect of the matter be taken into consideration, or the delay in filing the appeal
Paragraph 23 and 24 we have stated in our petition, page 30.
and has submitted that the appellate authority ought to have condoned the delay. He has referred to paragraph 23 and 24 of the writ petition
Read between it up. Page 30.
to submit that the petitioner had filed the appeal along with petition for condonation of delay, and after receiving the order of the controlling authority dated 23/11/2023, the petitioner took all steps and initiated a note for taking necessary approval from the competent authority for filing appeal before the appellate authority. The aforesaid process took some time in finalizing the records for filing appeal, and the petitioner being a central government/public sector undertaking, it is essential to take approval from the competent authority for filing appeal. However, such plea was rejected by the appellate authority. After hearing the learned counsel for the petitioner, this court finds that the matter was taken up on 9/12/2024, and it was argued by the counsel for the petitioner that the appointment of the ex-employee, namely Vishwanath Bhuya, was a nullity in the eyes of law as he had impersonated himself. And during the course of argument, the learned counsel for the petitioner was not able to satisfy this court as to whether any disciplinary proceeding was ever initiated against the ex-employee or whether any criminal case was instituted, and he was convicted in the criminal case with regard to impersonation. However, the matter was adjourned as he prayed for time for filing supplementary affidavit. However, no such supplementary affidavit has been filed, nor any prayer for adjournment has been made in the cases by arguing the case matter. This court also finds that the appellate authority, that one of the grounds which was raised before the appellate authority was that the ex-employee had impersonated himself, and the ground on which such plea was raised was that the fact was examined by the police, and according to police verification report, he was actually Vishnu Mondal and obtained employment for him. Even in the grounds of appeal, no such plea was taken that the ex-employee was subjected to any disciplinary proceedings or was convicted in any criminal case. And accordingly, the counsel for the petitioner has rightly not filed any supplementary affidavit, as that was never the ground of the petitioner before the appellate authority. This court further finds that the ex-employee was never convicted in any criminal case for impersonation or for obtaining fraudulent employment, nor he was subjected to any disciplinary proceedings culminating in any passing of any order against him. In such circumstances, on the face of the record, this court finds that the order of the controlling authority directing the petitioner to pay gratuity to the wife of the ex-employee does not suffer from any illegality or perversity. this is over and above the fact that the appellate authority has refused to entertain the appeal as the same was barred by limitation. The appellate authority has referred to the provision of law which empowers the appellate authority to condone delay only to a period of 60 days beyond the 30 days for filing the appeal. This court finds that the appellate authority has passed a well-reasoned order while rejecting the petition for condonation of delay. Further, in the memo, in the writ petition also, that should be sufficient. Considering the totality of facts and circumstances of this case, this court finds no merit in this writ petition, which is according to this case.
Well, 60 days is the first limit, Your Lordship, and thereafter 60 days for preparing.
120 days.
120 days. My lordship recorded 30 days initially.
Line is
60 and 60.
Petitioner का ही लिखिएगा. The learned counsel for the petitioner submits that there is a provision for preferring appeal within a period of 60 days, which can, and there is further provision of condonation of delay of further 60 days, and the total period is 120 days. The perusal of the order reveals that the finding has been recorded by the appellate authority that the controlling authority the controlling authority has recorded that the petitioner received the order on 23/11/2023. On 30/11/2023, and the appeal was preferred on 27/5/2024, and it is not in dispute that the appeal was filed beyond total period of 120 days. Correct?
My lordship.
Merit पे भी करते हैं कुछ.
Deeply well, Your Lordship.
For hearing item 4, the WPC 4225 of 2001, along with Jharkhand Court.
Today we have received instructions, not as so has been signed by the competent authority. Within 2 days we will file counter.
You don't need any.
Within 2
कोई
days.
जरूरत ही नहीं है आपके काउंटर का. आप सूट में देखें क्या क्या plea है?
That is pending. The suit is pending.
You have taken the plea that this order is a nullity. You have taken all these plea before
But
this.
the suit court will not interfere with this order. We have not made a prayer. I will have to make a prayer that this order is valid. That's a coincidence. Because I have two things to say.
You see, and one more thing, in one of the repetition, you have made that Thawani as respondent, right? All the processes have been completed. And in the suit, we find that he transferred that property by way of gift, by a registered gift. So many foundational pleadings are not there in this.
But I am just confining it to one thing. Let us keep it very simple. I have just examined the provision. This is an order passed purportedly in terms of 73 of the Chotna Court.
That will be subject to suit because there are so many disputes in
But the state is not a party there.
State may be in
But you are making so many allegations against the state.
That is not incidental pleading. That's what I'm saying. Here the
It
veracity.
is not incidental. You are saying it's a nullity. Had no jurisdiction to pass the order.
Correct.
These are the things that you
But I
are.
have not questioned that
We
order.
do not know what issues have been framed before the court.
The suit latest before your lordships. We have also said that his writ petition was pending. But let's
So,
kindly have a look at the
You
prayer.
will have.
We are
No,
only.
we are not. You see, you have made statements.
Hello?
Just see.
It's only.
It is without jurisdiction.
Yes.
There. So.
Because I will have to make that. I have to make full disclosure that this is an order. It is without jurisdiction. I am challenging it. That does not take away my right to challenge it. I am on the very foundation of it. I have examined section 73 again. Now, I
You
am
see,
not.
you have got in one of the case, which one? Other one, Ashok Kumar Singh, perhaps. Yes, this case, the private respondent, right? He must have expired. We do not know when did
I
he
have not
expire.
made him a party.
There is a party in this.
I am not the
You do
petitioner in
not
that
know
case.
who is-
I am not the petitioner. of
So
that
firstly,
case.
this case should be dismissed. If you are not a petitioner there,
I
we
am
don't
not-
bother about it.
No,
We
Mr.
don't
Roy,
argue this. We will dismiss it.
Mr. Roy was appearing last.
He is not here.
He is not here. So I
This
am
Jwala
not.
Prasad Thania, He is a party in this case. He must have been deceased by
No,
now.
That's correct, but my dad.
Then
I have no knowledge because it is his
he had
reputation.
executed some registered gift way back in 1938. I'm sure he must have expired.
Yes, yes, most certainly. That's the source. That's the first transfer, 1930. But whatever it is, a dispute between me and them or any private individual
You see,
cannot.
we will not hold that state as a landlord
cannot.
under the definition will have no jurisdiction to declare
Kindly
any
don't-
land as abandoned land.
Kindly do not go, because I will not even urge that much. Let me be very clear, Lords, I am not even going that way. I am on a very simple. Can I just, therefore I am saying, can I make a very simple point? Let me assume state is a landlord, state can invoke section 73.
That's
Let us not go into that question. Kindly have a look at 73, just for a moment. The order,
आपको किस लिए टाइम चाहिए?
Statement of fact is written not 2 days time.
So in the midst of the proceedings, why didn't you inform this court earlier?
This last time.
You will have it as a matter of leisure. Yes.
Last time they couldn't appear because their name was not appearing.
Whose name was? He was very much there on the last date.
I was not there. Not some.
My lord.
Somebody was there. I don't remember.
Somebody was there.
So?
One of the case notes he is.
Proxy.
One of the case notes, 2 cases are there.
Yes. He was not appearing at his own peril. No, we will not. He has not informed this court.
2 days accommodation.
What 2 days accommodation? You want to? No, there is no question of 2 days or 3 days accommodation. What is this? You just look at the order. The precondition of 73 is not satisfied in the order. Somebody is there on the property. How does he acquire the right? It is not a case that the land is lying abandoned or vacant. Yes? Bataiye.
He was found in illegal position by the
Illegal possession is a different thing altogether. A person may be in illegal possession. You get him evicted.
I mean, serial number 5.
But I have a very simple thing. Lord should give me 2 minutes. I am not on anything, Lord. I am only saying 73(2) is the procedure, and they have not followed the procedure, and that will vitiate the entire thing. If the state thinks that it has the right to evict me because I have voluntarily abandoned land, it may initiate a fresh proceeding in accordance with law. I have a very simple solution to it. Kindly have a look at 73(2). 73(2) says that an application will be made by the landlord to the deputy commissioner in the prescribed manner. Prescribed means prescribed by rules. Rule 21 says that it will be an application will be made in the form number 6. All these things are absent.
We do not know. Records are not there before us.
The order shows that it was initiated on a report by the Kanun Go. That is what it says. It was not even an application, it was a report by the Kanun Go.
You see, when you say that this proceeding was not followed,
There was some of the
there is no. Why? You see,
already
there is
titles is
no
binding
foundation
to the party.
pleading also to that effect in your
But
petition
also
that
this
this
is
procedure
subsidized.
was not followed, this notice was not issued in the prescribed form. We do not know.
I was not even noticed. I am only
Please
saying.
tell me, आपकी jurisdiction
नहीं, हम
का
तो आप तो कह रहे
point है।
सर्चराइज जुरिस्डिक्शन है, आपको रिकॉर्ड्स मांगा के आप देख लीजिए, मतलब हम तो कुछ नहीं कह रहे।
हमको तो क्या ही देखना है? आप लोगों को तो एडजमेंट के अलावा कुछ चाहिए ही
हम तो रेडी, हम सब कर
कुछ ready नहीं है।
हम तो आपके सब पढ़ के आए। हम तो ये आप तो 12 बजे 1 बजे तो दोनों पढ़े।
आप 12 बजे तक पढ़ते हैं तो हम भी थोड़ा देर पढ़ते हैं।
आप तो पढ़े। So therefore, I am there. I thought about it. That the question I will not go into whether state is a landlord.
Just a minute. आपको इंस्ट्रक्शन मिल गया पैरावाइज कमेंट फाइल करने का, तब तो रिकॉर्ड भी मिल गया होगा, करेक्ट? रिकॉर्ड नहीं मिला और पैरावाइज कमेंट फाइल करेंगे आप बिना रिकॉर्ड के?
Question which was raised by the Hon'ble.
What question? We are not raising any question. We are just recording the submissions, right? Who has given you instruction? Who has given you instruction?
Statement of fact has been signed, but I have been informed not.
Who has informed you?
But the legal service not. They were I was playing for 2 days. I have received the instructions not.
क्या statement of fact मिला?
Statement of fact.
2 days time.
2 days.
तो फ्राइडे को करते हैं?
हाँ Friday.
Friday is half.
सबको तो टाइम ही चाहिए ना।
Right.
हमको नहीं चाहिए मिनट हम
कोर्ट तैयार है, रेस्पोंडेंट तैयार है, पिटिशनर ने तैयार
No,
है।
I am only indicating that because we have come, that notice has come to the full court. Sorry for just that notice has come. You should have it on Friday. I have no difficulty. I am making it very clear. I have 2 submissions.
फ्राइडे तक नहीं आएगा, इसीलिए फ्राइडे को रख रहे हैं। आपको पता है ना हाउ डज अ स्टेट फंक्शन?
Friday को बोले.
एक रिक्वेस्ट
Record
है,
लिख के।
फ्राइडे को रिकॉर्ड्स भी ले आया तो ठीक है।
आप रिकॉर्ड लिख लेते। आप हमको जरा इतना समझाइए, बिना रिकॉर्ड देख के आप स्टेटमेंट ऑफ फैक्ट कैसे बना सकते हैं? नहीं बन सकता है ना, कि बन सकता है? यस?
वेरीफाई कर 2 दिन का समय दे दिया।
और इनको सूट का कॉपी दिए हैं आप?
दे दे उसकी दे दे।
सूट में लिखे हैं आपका विदाउट जुरिस्डिक्शन है, कुछ है, आपको कुछ होश है? And it is not a thing that in a suit this issue cannot be decided.
No, because of the bar.
No, there is no part, because I was just coming, I came across a judgment of our court where this issue was taken up in suit. Where is the bar?
Kindly section 258. Kindly have a look at section 258. 258 of the CMT Act. Kindly. Because there is a direct express bar
For what?
for suit to decide the validity of an order passed under 73.
Section?
258.
Yes, please. Read it.
Save as expressly provided in this act, no suit shall be entertained in any court to vary, modify, or set aside, either directly or indirectly, and decision, order, or decree of any deputy commissioner or revenue officer in any suit, application proceeding under sections 20, 32, 35, 42, 46, your lordship will find 73 is there, except on the ground of fraud or want of jurisdiction, and every such decision so and so.
ये फॉर्मेट के बेसिस पे हम आपका केस नहीं है ना?
नहीं, I have two submissions.
The
to me.
condition precedent is not
No,
satisfied.
that is what I'm saying. I have two submissions to me. One is the procedure, one is the substantive. That you have given a finding of voluntarily abandonment without there being any evidence to that effect. You can. I am not. So first is the prescribed format, procedure, that is can hold directory. But the finding is that voluntarily abandonment and failure to pay rent, because mere failure to pay rent, there is suits are for recovery of rents are provided under the CNT Act.
Mere failure of rent is
not a ground. So it has to be intention
Voluntary abandonment
leading to failure of rent. Leading to failure of rent.
coupled with
Yes.
failure of rent.
That, and their finding
But
is
a third party was in possession of the property.
possession. I am saying
Then
that
whatever be the nature of possession,
illegal. He is in possession.
maybe illegal possession, but
But I am for a moment also agreeing with them that it's a question of the Rayat voluntarily abandoning the land, the state will take recourse. If someone is in illegal possession, state can not evict him through this order, that's a different thing, but can pass an order. I am saying, but where is the fact that I have mere non-payment of rent is not sufficient. Voluntarily abandonment, we have to then develop the law, is like my desertion in marriage. I must have the intention to abandon.
is there any direction to evict?
No, they have just said, but that's the point.
So you are not the Rayat. Admittedly.
I am the successor in interest.
No. Successor in interest in what sense? What is you have not produced any document to that effect.
No, I have the sale deeds in my favor from the. I have
From
the
whom?
chain. Yes, my title has flowed from Mr. Tandania, then to another person, and
How?
then to.
What is the
But
sequence?
in the next case, they are claiming the property by way of adverse position. I
I
can't
have
kindly
given
read
the
the
note.
43. They are claiming from
Let
adverse
me
position.
just let us
So
understand.
the land is registered seal deed. Jayraj Puttar transfer it to Mr. Tandania. I'm just giving the chain. One Mr. Dandania, then Mr. Dandania in 1938 gifts it to Ram Jivani Devi. Now this heirs of Ram Jivani Devi give it in 1976 to some Modis, and then the 7 sale deeds are executed by Modis in the year 2000 in my favor. This is this chain.
These documents are also not there with us.
My sale. No, not
Nothing.
record of right is there, only record of right showing this chain. Because I was wrong. These documents are not there.
In the record of right, the name of Tandania is
Tandania.
available. And it is
And it is Chaparban. And there are municipal tax holdings which is an admitted fact. So the answer to is, if it's a municipal holding on which there is a building, it cannot be a Rayati land. It's a land under the municipal authority. So there are larger questions. But I don't want to go into it, because your lordship is right, because these foundational facts are lacking. I was on a very superficial level saying that they failed to follow the procedure, and the finding that failure to payment of rent is solely not a ground to pass an order. There is no evidence of voluntary error. So there is perversity on the face of it. These are the two grounds I will take.
The recorded tenant, Tantania, never appeared, never objected.
Because
He
he had
never
transferred.
objected.
Because he had transferred by
Because
them.
he had transferred
But
his
he had no
right.
interest in the land.
So that transfer was.
It is still standing. No one has challenged. No one has challenged. No one has challenged. Therefore, registered sale deed is there. My point is, Manoj, I feel strongly that after vesting of the land, this provision the state cannot invoke. Now, state can be a landlord in certain cases. I am not saying, but when it is the paramount owner, when it's not my landlord, the paramount owner, it cannot. It is not a
There
means
could
of.
be a situation where suppose somebody dies without a hearing.
Yes, that
He does not. There is cheat.
escheat. I
That's
absolutely
it.
agree.
It is basically a proceeding, a provision parallel to that,
Absolutely that.
to
It
some
is a-
extent.
Absolutely, escheat is the right word, Your Lordship. So that is it. Res nullis, escheat, these are the words. That no one is claiming the property, then the state will take it under its control and then deal it as state's property. But here, if someone is claiming, I can leave my land, my lords, just like.
Yes, who has given you instruction? And in which case do you want to file an affidavit?
Serial number 5.
Serial number 5 is writ number 2800.
2800.
And what about WPC 4225? Yes, respondent 4225.
You filed the court.
You have filed a counter claim. Who has given you instructions? A legal department. CWJC number 2800 of 2000 within bracket R with WPC number 4225 of 2001. The learned counsel for the parties are present. These two cases arise out of same proceedings.
Yes.
The matter was heard Where is the last note? Heard at length on 12/12/2024. And the arguments were also recorded and the case was treated as part heard. The matter was posted for further hearing today. When the case is taken up, the learned counsel for the state appearing in CWJC number 2800 of 2000 within bracket R has submitted that he has received instructions in this matter and wants to file a counter affidavit. This court finds that the prayer for filing a counter affidavit has been made in a part-heard manner and no further and the order to file counter affidavit was filed way back on 31/8/2000. No advance notice seeking adjournment on this ground has been circulated. And this court has also spent time in going through the records as contested points are involved in this case. However, the counter affidavit of the state is necessary. The counsel for the state has prayed for 2 days time. 2 days time. Pose this case day after tomorrow. Day after tomorrow, no, Friday. On Friday. Awaiting the counter affidavit of the state in CWDC number 2800 of 2000 Lakadar. Subject to payment of cost of rupees 10,000 to be deposited.
We are filing the point of on the law points only.
कोई बात नहीं.
The law point requires Hon'ble.
Yeah, let this-
comprehensive point of affidavit is being filed.
On the-
But kindly see we are filing on law points
इसमें
only.
क्या बात है? 10,000 रुपए जमा करिए. In the High Court Legal Services Committee.
But we are only answering the query raised by Hon'ble Court, not.
You just-
Law points पे only file करना है point of affidavit.
कोई
3
बात
law points था.
नहीं. Law point में फाइल करिए, फैक्ट में फाइल करिए. We don't bother about it. Okay? आपको फाइल करना है काउंटर, आप the counter affidavit is filed on by Friday.
Let the counter be filed on Thursday, at least a copy be served. I have to.
Just a minute. नहीं ऐसा कर. Let the counter affidavit be filed by Friday. The rejoinder, if any, by seventh of January. Pose this case for further hearing on 10th of January under the heading for final disposal. The counsel for the state will also produce the connected records. वो भी produce करिए, फिर क्या ही है? Right? Counsel for the petitioner has also submitted that the required procedure as per the provisions of section 73 subsection 2 has not been followed in the present case, which can be demonstrated if the records are.
Yes.
ठीक है? Records से आप वो भी procedure भी demonstrate करें.
Only the cost amount may be reduced.
Sorry?
Only the cost amount may be reduced.
नहीं. I also
हमको
humbly
2 ही
pray.
दिन का समय मिला.
I also humbly pray कि आगे से ऐसा ना करें.
हमको 2 ही दिन का समय मिला था. किसी और ऑफिस में था मेरे ऑफिस में आया.
आपके ऑफिस का प्रॉब्लम से हम लोग को लेना देना नहीं है. आपके काउंसिल ने उस दिन ये भी नहीं बताया कि he was appearing only in one of the cases. ठीक है? He never said.
Old matter.
ओल्ड मैटर है तो क्या हुआ? जमीन ओल्ड नहीं होता है. जमीन पर राइट हमेशा चलते रहते हैं. आप इस तरह से किसी के साथ नहीं कर सकते. ओके?
Cost will be paid to whom?
झारखंड हाई कोर्ट लीगल सर्विसेज अथॉरिटी. आपको क्या है? एक पॉकेट से दूसरे पॉकेट में जा रहा है. क्या ही फर्क पड़ता है? ये दोनों का ऑर्डर एपिलेट अथॉरिटी, अपील है ना, एंड द ओरिजिनल अथॉरिटी. अब दोनों का रिकॉर्ड प्रोड्यूस करें. इन केस रिकॉर्ड ना प्रोड्यूस करें तो एडवांस में नोटिस भी देंगे और आईए भी फाइल करेंगे कि रिकॉर्ड्स क्यों नहीं प्रोड्यूस कर पा रहे, क्योंकि हो सकता है खोजने में टाइम लगे. ठीक है? सूट का कॉपी इनको दे दीजिए.
हम दे दिए ना.
थोड़ा भी बुद्धि होगा तो इंटरवेंशन फाइल कर देंगे सूट में.
Item 6 WBC 5704 of 2003.
Because on the last occasion, Mr. Manish Mishra had appeared and said to us that he cannot appear in this case since he is on the panel of the state lawyers. As I have received a fresh Halaknama today, rather than filing it,
You don't give advance notice for adjournment. I'm absolutely clueless. Why didn't you give advance notice that you want to see?
Lord, I have already received instructions yesterday evening that I have to appear in this matter. Because then we don't even have a copy of the brief.
Where is the electricity board?
On the last
You have
occasion
received
also,
instruction and your petitioner has not given you the brief.
my
They are
lord,
briefless.
my lord, the council, previous council does not have a brief.
Wakalatnama must have been received from the client.
My lord,
You want to say Tata Steel, they do not have the records.
my lord, Tata Steel may have the records, my lord. I have received the no objection from the previous council, my lord.
Wakalatnama is executed
My
by the
lord,
client.
they have executed it, my lord, but they have not yet given.
Where is the electricity board? They have not even filed any counter affidavit in
They
this
have
case.
not filled it, my lord. There's a
There
supplementary
is a
affidavit.
stay of certificate proceedings.
Yes, my lord. I have received the orders.
Very good. उनको बुलाइए, Mr. M.K. Roy को बुलाइए. Let them come.
My lord.
Right. Because next day they will seek time for filing contract. So let him come. You just wait for some.
I will also request for a soft copy if it is.
We will give you
available.
everything.
My lord.
You get the wakalatnama ready and file it during the course of the day. Get it ready.
We
right
will
now.
file it.
Just wait for some time. Come at 12 o'clock.
From date list for final disposal, item 1, WPC 5149 of 2003, along with item 2 and 3.
Petitioner. Which record should I take up?
First 2003 matter.
5149. Let us have a.
Because the subsequent repetition has with respect to different period.
Analogous.
Otherwise, these matters.
Issue is the same.
Issue is the same.
Yes.
The prayer is for quashing of order dated 11/3/2003 passed in revision miscellaneous petition case number of 1 of 2003 by learned Deputy Commissioner Devghar, whereby and whereunder he has been pleased to dismiss the revision miscellaneous petition case number 1 of 2003 on the ground that the petitioner has already filed representation before the assessing officer, that is notified area committee, from sub-divisional officer Jamtara, to review the illegal abnormal assessment of rent tax for the railway siding at Jamtara by notified area committee of Jamtara, and if the petitioner is aggrieved by any order passed by it, then he may approach him, but the notified area committee cum sub-divisional officer Jamtara has not disposed of the representation of the petitioner and has taken coercive step for realization of the same. And further, to quash the illegal abnormal assessment made by respondent number 3 and 4, via notice number 07 dated 24/1/2002, that is Annexure 6.
No, I don't get
With-
it. What is the sequence of events?
Yes. First of all, Annexure 6 may kindly be seen
Give
in.
me the dates, please.
Yes.
This is relating to which period?
This is relating to period third quarter of 1992-93. To 2002-2003. This is with respect to holding tax and lighting tax.
Yes.
And commercial tax for the period 1997-98 to 2002-2003.
For the period?
For the period 1997-98 to 2002-2003. Two type of tax has been imposed, has been assessed, that is holding tax and lighting tax, and commercial tax.
Commercial tax, they have the power to levy commercial tax also?
No, that is our case, that no commercial tax, there is no provision in the Act for levying of the commercial tax. And as far as holding tax and lighting tax is concerned, with respect to the period third quarter of 92-93, it is our case that this land was acquired by the government by notification number 1861 dated 27/9/1991.
Where is the notification?
That notification is not on record, but we have given a statement. There are two notifications, and notification number 1862 dated 27/9/1991. Two notifications.
What is the description of property?
Property description is, it is at Moja Ghanghara, Moja number 6, and Moja Vaibha number 8.
Where have you mentioned?
That I have mentioned. Paragraph 5, that it is submitted that 36.03 acres of vacant land for construction of railway siding was acquired under the Land Acquisition Act by Land Acquisition Case number 5/1986 and Case number 6 of 1986-87 corresponding to notification number 1860, वो जो हम लिखवाए हुए
The description of property तो नहीं है.
Uh,
Anyways,
prop-
we'll see.
property का description we have property का description paragraph 7 said railway siding in question of Santhal Pragna Mines Chitra is situated within the Moja Ghanghara number 6 and Moja Vaibha number 8 Jamtara ward number 3 of the notified area committee Jamtara, and holding number that has been given is 284 of the state structure of railway siding at Jamtara.
So the appellate authority, the revisional authority, you had filed a revision?
But we filed an application, and the deputy commissioner said that you go and file a representation before the SDO who has assessed, but the SDO has not taken any step with regard to my representation. Thereafter this repetition, my first
Where is your representation?
representation that has not been annexed. That has not been annexed. The order, your lordship, which seeks quashing is annexure 24. That is order dated 11/3/2003.
Read the order.
I read the order. That is at page number 48.
48, yes.
Annexure 24. The representation against the assessment made by the is pending there. So notified area committee is pending there. So there is no point to
So he directed for
moving before the SDO Jamtara. In this case,
you moved before the SDO Jamtara after 25.
yes,
What
we
is
have
the
given
date
a
of
state.
it? Where is your statement?
That statement in the prayer portion
You
we
see
have
para number 27, what have you stated?
paragraph 27. That is submitted that there is provision of appeal against the order of assessment before the commissioner, but since the said post is lying vacant, the question of filing appeal does not arise.
Go and file your appeal. अभी vacant थोड़ी है।
अब हम खाली बता देते हैं कि ये हमारा पहला आर्ग्यूमेंट क्या है। सेक्शन 388 ऑफ द म्युनिसिपल एक्ट।
देखिए पहला आर्गुमेंट का बात है। आपका जो नेचर ऑफ इम्प्रूव्ड ऑर्डर, इट ओनली सेज इट हैज नॉट बीन डिसाइडेड ऑन मेरिट। पहला चीज वो सिर्फ इतना ही बोल रहा है कि आप अपना रिप्रेजेंटेशन करें। यू आर एग्रीड बाय दैट ऑर्डर।
हम इसलिए बोल रहे हैं कि जो हमको आप एसडीओ के पास में भेज रहे हैं, ही इज नॉट एम्पावर्ड टू act upon my representation for the reason that Section 388 of the Municipal Act has been deleted by the Constitutional 74th Amendment Act 1992, notified as on 20th of April 1993. Thus, notified area committee is no more in existence due to 74th Amendment of the Constitution of India. इसके लिए हम दो जजमेंट रिलाई करते हैं
SDO के पास
because SDO was never
asking you to go to SDO.
SDO who is an incompetent person.
SDO is incompetent. Who is
Incompetent.
competent according to you?
According to me, at that relevant time, notified area committee was not in existence because SDO presumes that he is the chairman of the notified area committee. Our case is that SDO was not the chairman of
I
the.
just want to know
Yes.
from you if SDO is not the competent authority. According to you,
Yes.
there has to be some competent authority. Who is that competent authority?
Yes.
In this, in para 27, you say that you cannot file an appeal because the vacant post is vacant, right?
Yes.
So you could have filed an appeal against the notice of demand, that is Annexure 25, which is the other document under challenge. Is it?
My document is challenged and that is Annexure
Yes,
6,
Annexure
page
6.
28.
Okay. Annexure 6, page 28.
Page 28.
This is an appealable order. Annexure 6, page 28 is an
This
appealable
is
order.
not an appealable order.
Then why have you stated so in para 27? It is in connection with which order? Para 27 of the writ petition is in connection with which order? बताइए.
ये जो असेसमेंट कर रहे हैं एनेक्सर 6 से इसका कोई अपील का प्रोविजन नहीं है.
आप ये para
वही लिख रहे हैं.
27 में क्या है?
Submitted that the provision of appeal against the order of assessment before the commissioner, but since the said post is lying vacant, this question of filing appeal does not arise.
So you have a provision of appeal. You have submitted that there is provision of appeal.
There is a provision of appeal
Yes.
against the said order of assessment before the commissioner.
Yes.
But commissioner तो कुछ exist ही नहीं कर रहा था ना post.
Lying vacant.
But since the post is lying vacant,
Yes.
reason your lordship.
That is the reason.
lying
कि उस समय
vacant
कोई
because
नहीं
that
होगा.
post वो notified area committee का ही ना commissioner का definition देख लिया जाए. Section
बताइए कौन सा सेक्शन?
जी. सेक्शन 2 का 29. सेक्शन 2 का 29 बिहार एंड उड़ीसा म्युनिसिपल एक्ट. ये देखते नहीं सर, ये वाला मैडम देखते उसी का फोटोकॉपी हम कुछ रेलेवेंट पार्ट हम फोटोकॉपी भी दिए थे.
ये तो सेक्शन 82 से चालू हो रहा
नहीं
है.
है इसलिए इस किताब से देखा
टेंडेंसी है इसमें. मैडम ये अगर मेरा इसमें रिटन डॉक्यूमेंट है तो वो लॉ भी हम कोट किए हुए हैं.
अच्छा अभी
दीजिए. हाँ बताइए कमिश्नर का डेफिनेशन.
कमिश्नर का डेफिनेशन देखा जाए सेक्शन 3 का सेक्शन 2 का 29. सेक्शन 3 का 29. सेक्शन 3 का 29. Commissioner means a person for time being appointed or elected to conduct the affairs of any municipality under this act.
Are you governed by the municipal law or not?
Yes.
Anybody who is the commissioner appointed under the municipal law
Yes.
is the appellate authority.
नोटिफाइड एरिया कमिटी का इलेक्शन होता है और उसके बाद म्युनिसिपल कमिश्नर जो कमिश्नर होते हैं वो प्रिसाइड करते
Elected
हैं.
or appointed. नहीं ये notified area committee से ही सिर्फ related नहीं है ना. It is for all the orders if appealable under Bihar and Odisha municipal act.
इसमें लिखता है इलेक्टेड टू कंडक्ट द अफेयर्स ऑफ म्युनिसिपैलिटी अंडर द एक्ट.
Yes.
Yes.
Appointed or elected दोनों है ना.
अपॉइंटेड और इलेक्टेड.
दोनों.
जो एसडीओ थे उसको स्टेट गवर्नमेंट कभी ऑथराइज नहीं किया कि यू आर हियर बाय ड्यूरिंग दैट पीरियड यू आर हियर बाय ऑथराइज टू एक्ट and conduct the affairs of the notified area. कभी उनको ऑथराइज नहीं किया गया और नोटिफाइड एरिया कमिटी का कमिश्नर इसलिए एग्जिस्टेंस में नहीं था बिकॉज सेक्शन 388 को डिलीट कर दिया गया by the 74th amendment.
So notified area was not in
Not in
existence.
existence. That is our case.
If notified area is not in existence, then you are governed by the general provisions of Bihar and Orissa Municipal Act,
Correct.
isn't it?
Yes.
So therefore the general provision of filing appeal would lie.
Assessment क्या गया?
आप तो अपना pleading से ही उल्टा बहस कर रहे हैं.
My lord, section 116, 116 is given the power of review of the review. And in this case, revised
Any
demand
person-
notice is given, that is Annex 25 of this writ petition.
There is a power of review
Review 116.
under section
116.
116.
पढ़ देते हैं. Any person who is dissatisfied with the
Where is
amount.
the power of appeal?
अपील का कोई
There
provision
is
नहीं.
no provision of
अपील वो हम गलत लिखे. Review.
Review, there is a power of review.
Review.
And there is no provision of appeal
अपील का कोई provision.
against the assessment. Are you
No.
sure?
Application for review 116. Any person who is dissatisfied with the amount assessed upon him or with the valuation or assessment of any holding or who dispute his occupation of any holding or his liability to be assessed may apply to the commissioner to review the amount of assessment or valuation or to exempt him from the assessment of tax.
So original order is passed by whom?
Original order has been passed by Annexure 6. वो पहला हमको नोटिस मिला.
Notice तो order नहीं होता ना.
Demand notice है.
वो
Annexure 6.
115(2) में हमको मिला. 115(2) देख लिया जाए. It says the chairman, उसी में ऊपर में है. The chairman shall also in all cases.
115(1) भी पढ़ेंगे.
हम 1 पढ़ देते हैं. When the assessment list mentioned in section 82 or section 105 has been prepared or revised, the chairman shall sign the same and shall give public notice by beat of drum.
So assessment is under section 89 or 105?
105.
89 or 105?
189.
89 and 105.
हाँ. 89 है assessment of tax on person. 89 assessment list to be prepared. When it has been determined that the tax shall be imposed on person in sole or joint occupation of holding within the municipality according to their circumstances and the property within the municipality, the commissioner, after making such inquiries as may be necessary, shall cause to be prepared an assessment list which shall contain the following particulars and any other which the commissioner may think proper to include name of the road, number of the holding, name of the person, the description of the holding, the amount of annual assessment, amount of quarterly, and if any person in occupation in holding is exempted from assessment note to that effect. 115 में बोलता है कि नोटिस दिया जाएगा, जो आप असेसमेंट कर रहे हैं उसका आपको नोटिस दिया जाएगा. वो नोटिस कभी नहीं आया. नोटिस पहला आता है 115(2) का हमको नोटिस मिलता है. दैट इज Annexure 6 which is under challenge. जब आप असेसमेंट कर रहे थे उस वक्त आप हमको कभी नोटिस नहीं किए और एक फिगर बैठा के 115(2) का हमको भेज दिए कि ये अमाउंट आपको देना है और 92 में कर दिए जब हमारा साइडिंग जब है वो एक्वायर हुआ था और हमको पोजीशन सिर्फ दिया गया.
So therefore, if there is any kind of error in the procedure regarding assessment, or if there is any error in quantification of the amount, there is a provision for review before the commission.
हमारा कंटेंशन है
under section 116.
है बिल्कुल है, लेकिन हमारा कंटेंशन है कि जो असेसमेंट किया गया चेयरमैन कहते हैं कि हम चेयरमैन हैं नोटिफाइड एरिया, एसडीओ खुद कहते हैं कि हम चेयरमैन हैं नोटिफाइड एरिया के, वो नोटिफाइड एरिया कमेटी एग्जिस्टेंस में था ही नहीं। नंबर वन, एसडीओ को कभी स्टेट गवर्नमेंट ऑथराइज नहीं किया था कि आप इस नोटिफाइड एरिया कमेटी का इस बीच में आप जो है चेयरमैन रहेंगे, आप एडमिनिस्ट्रेटर रहेंगे और इसका संचालन करेंगे, ऐसा कोई भी डॉक्यूमेंट ये लोग नहीं लाए।
तो जब आप बोल रहे हैं कि
जी।
नोटिफाइड एरिया कमिटी एग्जिस्ट ही नहीं कर
नहीं कर रहा
तो
था।
फिर देयर इज नो क्वेश्चन ऑफ एनी नोटिफिकेशन और एम्पावरिंग हिम टू डू एनीथिंग।
नहीं, नोटिफाइड
With
एरिया,
respect to notified area
ये जो
committee।
बोलते हैं ना
नहीं,
कि
नहीं, आप notice
हम
से-
खाली एक बात खाली बताते हैं, ये बोलते हैं कि एक सेविंग क्लॉज है कि जब तक दूसरा बॉडी नहीं आ जाएगा तो ये बॉडी एग्जिस्ट करेगा, ये चलाएगा। लेकिन ये चलाएगा तो उसके लिए स्टेट गवर्नमेंट उसको नोटिफाई करके बोलेगा कि फलना ऑफिसर जो है वो नोटिफाइड एरिया कमेटी का एडमिनिस्ट्रेटर होगा या कोई भी जो भी एग्जीक्यूटिव ऑफिसर होगा, ये
अच्छा,
होगा।
एक बात-
That notification has never been brought on record by the respondent till date.
You see,
जी।
you say that the notified area committee or those authorities have no jurisdiction.
Yes.
So you tell us who has the jurisdiction.
As per
क्योंकि
the
assessment तो होगा, भाई assessment of holding tax तो
जो-
होगा ना आपका।
जो-
Who is the jurisdiction? Who is the authority? who will do?
जो बीच का पीरियड है उसमें उनको अपना जो नगर पंचायत बनाना है वो सब बनाएंगे ये लोग। नया असेसमेंट ये लोग नहीं कर सकते।
कहीं मतलब assessment होगा ही नहीं holding tax.
उस पर्टिकुलर पीरियड का असेसमेंट वो कैसे करेंगे? आप 388 वो जो 306 दिखा रहे हैं
See, you say that there is no this.
दैट इज द जजमेंट ऑफ डिवीजन बेंच ऑफ दिस ऑनरेबल।
कि तब तक कुछ नहीं होगा।
नहीं होगा, दैट इज द डिवीजन बेंच जजमेंट।
दिखाइए कौन सा
हाँ।
जजमेंट है?
दो ठो जजमेंट है 1999 वॉल्यूम 3 और हम इसका जजमेंट पिछले डेट को दिए। हाँ, और उसी को डिवीजन बेंच कंफर्म किया 2003 में।
I have this 2004 judgment.
नहीं, हम दिए थे पिछले बार 1999 वॉल्यूम 3 पीएल
1999 volume 3.
द्वारकानाथ प्रसाद हम पढ़ देते हैं।
Hmm.
थोड़ा सा डार्क थे वो कॉपीज में, हम किताब लाए हम वो भी दे देंगे आपको। इट मे बी नोटेड हियर दैट दी पैराग्राफ 4 पढ़ रहे हैं। It may be noted here that following the 74th amendment of the Constitution of India, Bihar ये मैडम ये clear It may be noted here, paragraph 4 that following the 74th amendment of the Constitution of India, Bihar Municipal Amendment Ordinance 1994, Bihar Ordinance number 13 of 1994 was introduced with effect from 30th of May 1994. That is to say, about a month and a half before the issuance of the notification constituting the notified area committee in exercise of power under section 388 of the Act. Section 24 of the ordinance deleted section 388 from the parent act. Ordinance number 13 of 1994 was renewed by ordinance number 19 of 1994, which later on got translated into Bihar Municipal Amendment Act 1994, Act 2 of 1995. It is thus to be seen that on 14/7/1994, the provision of section 388 were no longer on the statute book, in exercise of which the notified area committee could be constituted, and in that circumstances it was submitted on behalf of the petitioner that notification dated 14/7/94, the government order number such and such were dead letters and void ab initio. And thereafter the last paragraph may kindly be seen, that is paragraph 10.
Just
हाँ जी,
it was deleted with what date? 388.
14/7/94 वहीं पर लिखा है, it is thus to be seen that on 14/7/1994 the provision of section 388 were no longer on the statute. ये 14/7/1994। अब इसका पैराग्राफ 10 खाली देखा जाए।
एक सेकेंड.
जी
74th amendment of the Bihar Municipal Ordinance 9 was introduced on 35/1990.
हाँ वो अमेंडमेंट हुआ ना, उसके बाद फिर ये लोग ऑर्डिनेंस से
इसी अमेंडमेंट से ये डिलीट हुआ.
डिलीट हुआ. इसी अमेंडमेंट के बाद ये लोग ऑर्डिनेंस लाए और उससे उसको डिलीट कर दिया वो प्रोविजन.
What is the effective date of ordinance 35/94?
पहला जो ऑर्डिनेंस है वो था 30/5/1994. दैट वाज
इसका
रिप्लेस्ड.
मतलब इस पर्टिकुलर डेट के बाद
जी
आपका ये
हाँ.
नोटिफाइड एरिया नहीं.
कमिटी नहीं.
तो
उसके बाद
14/7/1994 को नोटिफाइड एरिया नहीं.
नहीं.
ठीक है. And therefore the subsequent letter dated 19
ये तो उस केस का था.
हाँ,
उस केस का था. उससे हमको मतलब नहीं.
794 was not in existence.
वो
was
तो
void ab initio.
उस केस में
अपने केस का फैक्ट.
आपको नहीं पता. अब पैराग्राफ 10 खाली काइंडली इसी का जजमेंट का खाली.
पैरा 10.
Para 10. It follows that the levy of entrance tax, ये entrance tax के बारे में था, imposed by the so-called notified area committee was bad and invalid, and no entrance tax can be collected from the petitioner or from any other similarly situated person. Similarly situated person.
इसमें आपका तो एंट्रेंस टैक्स का कोई स्टोरी नहीं है.
स्टोरी नहीं है, लेकिन नोटिफाइड एरिया कमिटी कोई काम नहीं कर सकता है, वही है इसका क्रक्स. उसके बाद
ये पैरा 7 भी पढ़ेंगे.
पैराग्राफ 7. Paragraph 7. From the above order, it is manifest that this court had given the state government 3 months. ये उस केस से था.
पढ़िए ना, पढ़िए.
जी 3 months time for following the procedure as envisaged in the act for constituting a municipality. उसमें टाइम दिया था कि आप 3 महीना के अंदर में म्यूनिसिपैलिटी बना लीजिए. Failing which, it was directed that the notification dated such and such annexure 1 to the petition would stand automatically cancelled. That the judgment was delivered on 24/1984. The state government having failed to comply with the procedure laid down in the act for constituting a municipality within the time allowed by this court, the notification dated 14/8/1987 stood cancelled long ago, and that episode was thus over long before the present notification dated 14/7/94 was issued. The present notification cannot therefore be viewed as being issued in furtherance of the liberty given by the court or as to the part of the earlier episode, and I have no hesitation in holding that by the impugn notification dated 14/7/94, Suhar notified area committee was being sought to be constituted afresh without having any connection with its earlier constitution in 1987. और ये लोग जो है, जब ये डिलीट हो गया, ये लोग 2006 में जामतारा नगर पंचायत बनाए. 2006 में बनाते हैं.
But your timeline here, just tell us. Your timeline in this case.
हमारा जो टाइमलाइन है, जब ये 14/7/94 को ये डिलीट हो गया.
Yes.
दिस इज
35/94 को.
35/1994. उसके बाद ये लोग असेस करते हैं अनेक्शर 6 से. हमारा अनेक्शर 6 का डेट देख, हम ये खाली एक
नहीं, आप ये टाइमलाइन बताइए ना. इसमें नोटिफाइड एरिया के कब के बोल रहे हैं? कोई नोटिफिकेशन नहीं है नोटिफाइड एरिया का कि है?
ये कब बना था? ये कब
बना था नोटिफाइड एरिया?
नोटिफाइड एरिया तो शुरू से बना हुआ होगा.
पहले से बना.
2022 से पहले से बना हुआ था.
मतलब 1994 के पहले से बना.
हाँ बना हुआ था. उसके लिए हम
इसमें ऐसा नहीं है कि पहले से बना हुआ था.
इस
जजमेंट में पहले
नहीं, ये केस में पहले 2 महीना पहले बना था. बाद में इनको टाइम फ्रेम दिया गया कोर्ट के द्वारा कि आप जो है,
वो सब नहीं. इसमें जो है नोटिफिकेशन ऑफ द नोटिफाइड एरिया कमिटी was subsequent to the amendment, was subsequent to the ordinance dated 35/1990.
This is my case.
In this judgment which you have cited, that provision of notified area committee was deleted on 35/1994, and the notification was subsequent thereto. Therefore, the court held that there is no question of any notification for constituting notified area committee post the ordinance.
It is
fair enough.
It is otherwise. ये 2 महीना पहले था. पढ़ देते हैं पैराग्राफ को उसी जज।
अभी आप ही जो
नहीं,
टाइमलाइन
हम
बताए, 4 बार आपसे टाइमलाइन पूछे तो यही टाइमलाइन
नहीं नहीं हम बता देते हैं।
बताइए।
30/5/94 का है ना ऑर्डिनेंस
ऑर्डिनेंस
13।
है, हाँ।
It was introduced by 30/5/94. That is to say about a month and a half before the issuance of notice.
That's right.
Before पहले से एक्जिस्टेंस में था ना
नहीं
notified date।
नहीं, 30/5/94 का जो ऑर्डिनेंस है, इट
जी।
केम इनटू इफेक्ट दैट जो नोटिफाइड एरिया कमिटी का जो नोटिफिकेशन था, दैट इज 14/7/1994 और 19/7/1994 एंड इट वाज प्रीसीडेड बाय द ऑर्डिनेंस। ये है जो आप पहले बोले थे, बिल्कुल सही बोले थे। तो यहाँ पर जो है द नोटिफाइड एरिया वाज एग्जिस्टिंग प्रायर टू दिस।
हाँ ठीक है प्रायर टू दिस है, लेकिन वो डिलीट हो गया।
कैसे डिलीट हो जाने से कैसे वो खत्म हो जाएगा? नाउ ही इज रेफरिंग टू द सेविंग क्लॉज। यू कम टू द सेविंग क्लॉज।
Yes.
बताइए सेक्शन कौन सा है?
390C में ये बुक
Three-
में होगा, बुक में
390 इसी
सी
में?
बुक में बुक है या जो हम ये रिटन आर्गुमेंट दिया उसमें वो कोट किया हुआ 390C
394।
390C यस
आप आधा सेंटेंस बोले 394।
390 390
390 का सी इसमें भी वो कोट है।
ठीक है 390 पढ़िए। सेविंग
सेविंग
पढ़िए पढ़िए।
The municipality, the notified area committee on the commencement of this audit. मैडम इसको एक बार सेक्शन 390 से फिर इनको पढ़िए। 390 से पढ़िए। Construction of enactments and expenditures of proceeds of tax imposed in notified area. When any enactment, rules or bylaws is applied or adopted to, or any tax imposed in a notified area under this chapter, then unless a different intention appears, such enactment, rules or bylaws shall apply, and the proceeds of such tax may be expended in such manner as if the notified area were a municipality and the committee were the commissioners. उसके बाद जो हमारे पास किताब है 390A को कोट किया हुआ है, जो कि इस बुक्स का 390A से डिफर करता है। इसमें लिखता है 390A कन्वर्सन ऑफ नोटिफाइड एरिया
पावर टू मेक रूल्स। 390A इज पावर टू मेक रूल्स।
हम लोग के पास बुक सेम है, तो बुक अवेलेबल ही नहीं है।
अब ये अवेलेबल है कि नहीं है वो नहीं जानते।
वो टाइप कॉपी जो था वो फोटो कॉपी दे दिया जाएगा हमारे पास।
मैम बुक आप देख लीजिए, फोटो कॉपी जो है
हम लोग फोटो कॉपी से करते
ये
हैं।
वाला
नहीं
बुक का फोटो
आपके
कॉपी
पास नहीं है?
नहीं बुक
वही
वही
आपके
आपके
पास
पास
है।
है, दोनों वही पर है।
आप हमको ये दे दीजिए, ये आप ले लीजिए।
ठीक।
राइट।
कर देंगे। ये थोड़ा सा कंफ्यूजन है।
Amendment
कोई
के बाद का
confusion
बुक
नहीं।
है।
नहीं बिल्कुल कंफ्यूजन है, खाली हम
नहीं
आपको
है।
दिखा देते हैं प्लीज।
नहीं प्लीज, ऐसा स्टैट्यूट को लेके ना अब आपसे सवाल पूछ रहे हैं तो आप जो है
हम
इसको-
पढ़ेंगे पूरा। आप पुराना वाला जो हमारा एक्ट है उसमें 390A अलग से कोटेड है, हम उसको पढ़ देते हैं जो हमारे बुक्स में।
कहाँ है आपके बुक में? कौन सा बुक में है?
ये पुराना वाला बुक में तो आफ्टर ऑर्डिनेंस केवल एक ही सेक्शन नहीं चेंज, 380 नहीं चेंज रिपील हुआ था, बहुत सारे सेक्शन चेंज हुए। उसमें 390C एक है जिसको हम कोट कर रहे हैं।
ये आपका बुक कब का है?
ये पुराना वाला है।
आप
Before-
बाद इसके
before
बाद
ordinance।
इसके बाद का पब्लिकेशन में फिर यही बुक छपा।
गलत छप गया ना। पावर टू मेक रूल्स
ये 1989 का वो पता नहीं, ये वाला है
89, उसके बाद तो ऑर्डिनेंस आया ना।
जी
हाँ, तो ये पोस्ट ऑर्डिनेंस वाला किताब
जी।
पढ़िए। सेविंग पढ़िए ना,
हम पढ़
390C
देते
सीधा
हैं।
पढ़िए बस। पढ़िए
98 का
पढ़िए 390C। आप पढ़िए या नहीं पढ़ेंगे?
हम पढ़ दे रहे हैं।
पढ़िए।
रिटर्न आर्गुमेंट है उसमें भी कोट किया हुआ है।
390 पावर 390A पढ़ रहे हैं. Power to make rules. The state government may, by notification in the official gazette, make rules to carry out the purpose of this ordinance or for the matters connected therewith, or which are required to be prescribed by rules under the provisions of this ordinance. ये rules बनाने की बात बोलते हैं, ये लोग कोई rules नहीं बनाए. 390B, removal of difficulty. If any difficulty arises in giving effect to the provision of this act, the state government may, by order, as occasion may require, do appear necessary. 3 savings. The municipality, the notified area committee, on the commencement of this ordinance, shall cease to function as such, and the same shall be constituted in the manner and under the provision of this act, and such area may be declared by notification in accordance with the provision of subclause 1 and 2 or clause A of subsection 1 of section 4 of the act as municipal council and Nagar Panchayat as the case may be, provided that if any municipal area or notified area or part thereof is in the opinion of the state government not capable or being declared as municipality under the provision of this act, such area or part thereof may be governed by the provision of Bihar Panchayat Act 1922 shall continue to function till the constitution of the first meeting of the municipality.
प्रोवाइजर पढ़िए.
Provided further, notwithstanding the provision of this act, the municipality and the notified area committee, which were validly constituted under the Bihar and Municipal Act 1922, shall continue to function till the constitution and first meeting of the municipality. Notwithstanding anything contained in this act, anything done or any action taken by the municipal authority or the NAC in exercise of any power conferred under Bihar and Odisha Municipal Act 1922 shall be deemed to have been done or taken by the municipality or the panchayat as the case may be under the provision of this act or Bihar Panchayat Raj Act 1993.
Yes. You tell us what else.
Yes. हम जो दूसरा जजमेंट साइट कर रहे हैं दैट इज 2000 वॉल्यूम 3 PL पेज 736.
Two 2008 volume 3.
2000 वॉल्यूम 3 PLGR पेज 736.
ये फेयर कॉपी मैडम.
Paragraph 3. The ground on which the petitioner seeks to assail the orders are twofold. In first place, it is submitted that following the 74th Amendment to the Constitution State of the Bihar Act, which empowered the government to constitute a notified area by Section 24 of Ordinance number 1304, in effect from 30th of May 1994. Said ordinance was succeeded by series of ordinance till the ordinance were finally replaced by of 1995, 388 of the Bihar and Orissa Municipal Act, Constitution of the provision being duty notified area committee. There was no long area committee for Bakhtiarpur in the eyes of law, and no order of the kind coming under therefore be issued by sub-divisional officer in the capacity of chairman of notified area committee. Reliance in support of the submission is placed upon the decision of this court in Dwarka Nath Prasad versus State of Bihar and others.
Yes.
In this case, the notified area committee was in existence prior to this.
We do not know from where do we get this. What was the date of notification? Because this judgment is relying upon Dwarka Nath Prasad. Dwarka Nath Prasad was very clear that the notification was subsequent to the ordinance. So basically it is following Dwarka Nath Prasad. The ratio of Dwarka Nath Prasad is that there cannot be a subsequent notification creating notified area committee. Rather, the saving clause clearly says that the system will continue to function
System will continue.
till the fresh notification comes. The fresh notification has come only in the year
2005.
2005, and the entire proceedings are relating
and it has been
to prior to
concluded in
that.
the year 2006.
Yes, and the entire proceeding is prior to that period in
Right.
all the three writ petitions.
No, in third writ it is up to the 2008.
Okay, we'll see that later. But so far as this proceeding is concerned, and your primary grievance was that you were not given a hearing.
Yes.
That was your
At,
primary
at the time
grievance.
of assessment, no opportunity of hearing was given to me. Directly, the order, the notice that was issued under 150, that already it has been assessed and this is the amount that has been assessed.
So which section was not followed? Section 89.
89 was not followed, which is stipulated in 15(1). The time of assessment, the assessment is to be done under. That was never done. That divisional officer was never authorized to act as a chairman of the notified area committee during the period. Therefore, the action by the
Where have you stated that he was never authorized?
that is my submission.
You can't be. You see, there are two situations. One is this notified
We
area
say that-
committee was just a minute,
Ji.
was functioning prior to that ordinance, and by virtue of repeal and saving, the system continued. Therefore, a person might have been notified prior to this particular cutoff date, and even after this cutoff date, unless you have raised a specific plea to that
We
effect.
say that the SDO was having no jurisdiction. That stands.
But that no jurisdiction is
That's-
primarily on the ground of this judgment.
On the ground of that judgment,
Yes.
and he was never notified.
Where have you stated it was never known?
We say that the SDO was not having
You
any
just refer to the
jurisdiction.
grounds mentioned in the writ petition.
Subsequently, we have filed one supplementary affidavit.
Let us see your supplementary affidavit. You see, you have stated that you approached the notified area committee for disposal of your representation. That was never done. Then you say that at the time of no hearing was given to you, right? So this is which supplementary affidavit you have filed?
We have filed on 6/4/2010.
What stand have you taken? What stand have you taken in your supplementary counter affidavit? Supplementary affidavit. Which paragraph are you?
Paragraph 8. That it is stated and submitted that the respondent has not explained that under what authority it has assessed the tax ex parte under what authority has issued the said notice to the petitioner.
नहीं ऊपर पढ़िए ना पैरा एक पूरा ही पढ़िए.
पूरा पढ़ रहे ऊपर से ही पढ़ रहे. That it is stated and submitted
Has
that
not
respondent has not explained that under what authority it has assessed the tax ex parte and under what authority has issued it to the petitioner. And the present notified committee of Jamtara is not
This is not. This
existence.
is factually incorrect. This fact is factually incorrect. That distance, appeal and saving.
It is stated and submitted that the sub-divisional officer, who was ex officio acting chairman of the said notified area committee of Jamtara, in absence of elected body, has no propriety, competence, and jurisdiction to assess the tax and issue such notice. And as such, the entire action of the respondent is ab initio void, nullity in the eyes of law.
He was ex officio chairman of the notified.
He says that he is the ex officio chairman.
The 9.
9%. That it is submitted that on account of 74th Amendment to the Constitution, Section 388 of the Bihar and Orissa Municipal Act, which empowered the government to constitute a notified area committee, was deleted by Section 24 of Ordinance 13 of 1954. 94 होगा, introduced with effect from 30/5/1994. The said ordinance was succeeded by a series of ordinances till the ordinance was finally replaced by Act 2 of 1995, deleting Section 388 of the Bihar and Orissa Municipal Act. Consequent upon the deletion of provision, Section 388 of Bihar and Orissa Municipal Act being the basis for constituting notified area committee, there was no longer any notified area committee in the eyes of law, and no order of any kind.
There is no constitution of fresh notified committee after the coming into force of the ordinance. Once there is not there, then under that circumstances it was continuing. And so far as your quantum, natural justice, etc. is concerned, that will be taken care of by them. Therefore, you cannot say that the entire they had no jurisdiction to do it. That you cannot say. And now, since the new body has come up in the year 2005, the successor in interest, whosoever is the person, will look into it. I do not know who will look into it.
पहले का पीरियड का नहीं अब देख सकते.
My lord,
तो आप देखिए किसी को तो हम
in this
लोग
matter, in first writ petition, Annexure 25 is annexed by my friend. That is the revised order. The revision has been done. That was challenged.
रिवाइज को फिर वो और बढ़ा दिया, उसमें आगे कमर्शियल टैक्स भी ऐड कर.
I could show that how commercial tax is imposed.
just a moment.
His review, his assessment is reviewed by the authority. As far as the arbitrariness is concerned, my friend does not show what is arbitrariness. The annual value, how annual value calculated, this is given in the act. There is no discretion of the court. How much land he belongs, he knows. On that land, on the area of that land, annual value is counted. On the basis of tax, demand tax is percentage given. How much percent tax is imposed, like holding tax, that is given in act. There is officer that count otherwise.
Okay.
And on the basis of his representation, revised order is passed. He does not say how it.
On the basis of his representation,
Representation, yes.
Subsequently, we file a representation.
And on the basis of that, a revised order passed. That is Annexure 25 of the writ petition.
उसमें ऐड और कर दी, बढ़ा दिया.
Lighting tax, as far as the commercial tax is concerned, commercial tax is leviable on the petitioner.
Just a moment. Which is that Annexure 26?
Yes. Annexure 25, my lord. Notice.
And Annexure 25 is not under challenge?
This is the revised order. It is not challenged.
This Annexure 25 is not under challenge?
Subsequently,
This Annexure 25
is under challenge.
5/9/2003.
हाँ, चलिए. C prayer देख लीजिए, prayer number C. सब annexure का दिया हुआ है. To cause the illegal demand as met by respondent number 2 by annexure number 25. 25 is also.
So this has been passed on your representation?
My representation.
Where is your representation?
My representation is Annexure 7, 8 and 9.
पढ़िए क्या representation है?
पेज नंबर 29. उपरोक्त विषय के आलोक में सूचित करना है कि उपाध्यक्ष अधिसूचित क्षेत्र समिति जामताड़ा के कार्यालय सूचना नंबर 7 दिनांक 24/1/2002 के द्वारा एक नोटिस निर्गत किया गया, जिसके अनुसार वार्ड नंबर सच एंड सच, मकान नंबर सच एंड सच के संबंध में वर्ष 1985-86 का मकान टैक्स व लाइटिंग टैक्स का भुगतान हेतु निर्देश दिया गया है। इन संबंध में कहना है कि जामताड़ा रेलवे साइडिंग का निर्माण हेतु चित्रा कोलियरी के द्वारा मौजा सच एंड सच एवं मौजा नंबर सच एंड सच के अंतर्गत में 32.80 जोड़ 33.23 36.03 एकड़ जमीन का अधिग्रहण भू अर्जन अधिनियम प्रक्रिया के अंतर्गत भू अर्जन किया गया। उक्त जमीन जिला भू अर्जन पदाधिकारी दुमका के भू अर्जन वाद संख्या सच एंड सच एवं वाद संख्या सच एंड सच के द्वारा अधिघोषित संख्या सच एंड सच दिनांक 27/9/91 के अंतर्गत अर्जित की गई है तथा कोलियरी प्रबंधन के अधिपत्र में दिनांक 2/9/92 को उक्त जमीन दी गई है, जिसकी फोटो प्रति संलग्न है। उक्त जमीन का दाखिल खारिज करने के संबंध में अंचल अधिकारी जामताड़ा के कार्यालय में एक प्रस्ताव दाखिल किया गया। अभी वह विचाराधीन लंबित है, जिसका प्रति संलग्न है। जहां तक मकान और लाइटिंग का प्रश्न है, उसमें कहना है कि रेलवे साइडिंग स्थल पर मकान व लाइटिंग का कार्य 97-98 के प्रबंधक द्वारा किया गया। अतः अनुरोध है कि उपरोक्त विषय में संबंधित सभी तरह का टैक्स का भुगतान के संबंध में पुनः विचार किया जाए, ताकि यथाशीघ्र भुगतान संबंधी कार्रवाई की जा सके। और इसमें ये जो असेस कर रहे हैं, जो एनेक्सर 6 को एक बार देखा जाए।
आपका बेसिकली यही है कि 92 से आपने असेस कर
नहीं
दिया
नहीं,
है।
85-86 से जब अधिग्रहण भी नहीं हुआ था, एनेक्सर 6 देखा जाए ना। एक बार एनेक्सर 6 एक पेज पलट लिया जाए, पेज 28 में। इसमें बोलता है त्रिमाही मकान टैक्स इतना इतना आपको देना है, जो कि 1985-86 से लागू किया गया है। उस वक्त तो हमारा एक्वायर भी नहीं हुआ था। हमको आप पोजीशन जो जमीन को एक्वायर करके दिए हैं वो 2/9/1992 को दिए हैं। आप उसके पीरियड पहले जब हमारे पास में वो जमीन था भी नहीं, उस समय का भी आप टैक्स डिमांड।
तो आपकी लायबिलिटी कब से बनती है? 91 से, जब आपका अधिग्रहण हुआ 92?
नहीं, जब हमारा उसमें बना ऑफिस वगैरह बना, हम लोग जो साइडिंग होता है उसमें 1-2 ठो ऑफिस होता है, कुछ और कंस्ट्रक्शन नहीं होता है। बाकी लंबा सा एरिया होता है जहाँ पर हम लोग कोयला ला के रखते हैं, रैक लगता है और उसमें हम लोग कोयला उसको लोड करते हैं। दैट इज दी साइडिंग, वही साइडिंग।
So basically you had some grievance regarding period
पीरियड के लिए,
not the quantum. Not the quantum. You had the grievance regarding period.
वो
किस
हम
period
लोग
से
का जो
आप-
संचालन हुआ वो 97-98 से जो कमर्शियल
यही आपका रिप्रेजेंटेशन में पीरियड को लेके ही डिस्प्यूट है,
पीरियड को लेके लिखा गया।
ठीक है? एरिया वेरिया ये सब को लेकर, रेट को लेकर कोई डिस्प्यूट नहीं है। द ओनली डिस्प्यूट इज विथ रिगार्ड टू द पीरियड। 85-86
हम
से
लोग
भी
बाद में
आपको ले
बोले
लिया।
कि एग्जॉर्बिटेंट अमाउंट है।
नहीं, एक्सॉर्बिटेंट तो कुछ होता नहीं है ना। लॉ में देयर इज नथिंग एक्सॉर्बिटेंट। यू कैन हैव 200% टैक्स अंडर लॉ। इज देयर एनी बात? कहीं लिखा है कि इतना से ज्यादा नहीं होना चाहिए? लिखा है इनकम टैक्स इससे ज्यादा नहीं होना चाहिए?
हमको ज्यादा इनकम टैक्स मालूम है।
इसलिए उसका बात ही मत करिए।
हाँ, नहीं वो सब चैप्टर हम लोग छूते ही नहीं, इनकम टैक्स।
इसीलिए आपको बोल रहे हैं, ठीक है? यू हैड द ग्रीवेंस ओनली इन कनेक्शन विद द पीरियड। ओके, नाउ व्हाट
और जब
हैपेंड?
ये रिवाइज किया एनेक्सर 11 से पेज 33 में, तब ये एक नया अमाउंट कमर्शियल टैक्स का जोड़ दिया।
ये आपका फ्रेश ऑर्डर पास किए होंगे ना?
हाँ, एनेक्सर 11 में देखा
Presentation
है,
में?
पेज 33।
हाँ, पढ़िए जरा उसको।
कृपया उपरोक्त कार्यालय की नोटिस अनुशासन समान कार्यालय के प्रासंगिक पत्र का अवलोकन करने की कृपा की जाए। याद हो कि कुल एरिया 13.3000 वर्ग फीट आपके दखल कब्जा में पाया गया है। सरकार के प्राप्त निर्देश के आलोक में निजी उपयोग में लिए गए 10,000 इंटू 10 के लिए 1000 रुपया तथा अतिरिक्त व्यवसायिक उपयोग के लिए 340 समय की दर से कर निर्धारण करना है। इसके अतिरिक्त रोशनी कर लाइटिंग टैक्स और जल कर वाटर टैक्स की वसूली करनी है। इस निर्देश के आलोक में आपको दखल कब्जा वाले एरिया के लिए वार्षिक 1,38,300 रुपये, जिसका तिमाही 34,575 कर निर्धारित किया गया है, परंतु कार्यालय के भूल से व्यावसायिक कर इसमें नहीं जोड़ा गया है। उपयुक्त होल्डिंग एवं व्यावसायिक कर जोड़ने की इतना होता है, तिमाही 48,831 होता है। आपसे अपने पत्र में स्पष्ट उल्लेख किया है कि प्रासंगिक होल्डिंग टैक्स।
ये जो ऑर्डर है ना
जी,
दिस इज द अपीलेबल। ये जो रिव्यू है आपका,
जी,
जो कमिश्नर साहब के यहाँ आप गए थे, कमिश्नर साहब ने बोल दिया। कमिश्नर साहब का ऑर्डर कब का है?
ये है 19/6/2002 का।
2002 का। उसके बाद ये सब्सिक्वेंटली आपका रिप्रेजेंटेशन डिस्पोजल करके या वॉट एवर वॉज योर ग्रीवेंस डिस्पोजल करके एनेक्शन 11 ऑर्डर पास कर, इसी के अगेंस्ट में आप
हम लोग का कहना था कि एसडीओ को जुरिस्डिक्शन, हमारा सबमिशन लिखा दिया जाएगा कि एसडीओ को कभी ऑथराइज नहीं किया गया था स्टेट गवर्नमेंट
नहीं, पैराग्राफ दिखाइए, ऐसे नहीं चलेगा ना। ऐसे ओरल सबमिशन हम नहीं रिकॉर्ड करेंगे। जो आपका पिटीशन में है, जो पैराग्राफ है आप बताइए। ऐसे ओरल सबमिशन
वो नहीं लिखा हुआ है, लेकिन
नहीं लिखा हुआ है,
हमारा
तो हम
सबमिशन काइंडली लिख दिया जाएगा। हम
इट इज नॉट बोर्न आउट ऑफ रिकॉर्ड। आपका सबमिशन कुछ भी कैसे लिखाएंगे?
इनको कभी ऑथराइज नहीं किया।
We do not know. It is not born out of it. This particular order, which is at annexure 11, right? You have a remedy against this order, and that remedy is the remedy of review. The authority can examine the period, the quantum, the rate, and everything. They can examine every aspect of it. And that is why you have stated in your writ petition, कमिश्नर का पोस्ट खाली है, हम बाहर नहीं जा सकते। That is the whole
नोटिफाइड
purpose.
एरिया कमेटी एग्जिस्टेंस में ही नहीं था। मेरे
नहीं, वो तो हम होल्ड कर देंगे।
हाँ,
वो इशू हम डिसाइड कर देंगे कि भाई आपका ये जो नोटिफाइड एरिया कमेटी का जो ये ग्रीवेंस है, they have stated so in their I do not know।
अच्छा, इनका काउंटर एफिडेविट काइंडली देख लिया जाए। ये बोलते हैं कि पंचायती राज एक्ट के तहत में हम लोग ले सकते हैं, इसका काउंटर खाली काइंडली देखा जाए।
आपका नोटिफाइड एरिया कमेटी कब बना था?
2005 में बना, 2006 में कंस्टिट्यूट हुआ।
पुराना
हाँ, पुराना
मैडम बहुत पहले बना, उसका कोई रिकॉर्ड फाइल पे नहीं है।
इट वाज ऑलरेडी एग्जिस्टिंग,
एग्जिस्टेंस
ऐसा भी बोले हैं।
हम नहीं बोले,
नहीं बोले।
और एग्जिस्टेंस है।
कैसे आप ऐसे कैसे आसमान में बोल सकते हैं? कोई भी चीज एग्जिस्टेंस में है।
एग्जिस्टेंस है।
एक तो पैराग्राफ 12 इनका काउंटर का फर्क है। इनका काउंटर फाइल किया गया है, हमको कॉपी दिया गया था 8/7/2009। काउंटर ऑन बिहाफ ऑफ रिस्पोंडेंट और मिस्टर दास एफिडेविट की।
हाँ, बताइए।
पैराग्राफ 12 पढ़ा जाए, पेज नंबर 8।
पेज नंबर 8 पैरा 12। पढ़ी।
That with regard to the statement made by the petitioner in
पैरा
paragraph
10 भी देखेंगे ना सर?
हम
पैरा 10 पहले देखिए, उसके
पैरा
बाद।
10 that it is submitted that the respondent has not explained under what authority it has issued the said notice to the petitioner, and the present notified committee of Jamtara is not in existence, and at present there is no elected ward commissioner for a long time. It is stated and submitted that the sub-divisional officer, who is ex officio acting chairman of the said notified committee of Jamtara and has no propriety and competence and jurisdiction to assess the tax and issue such notice, and assess the entire action of respondent is ab issue void and is nullity in the eyes of. इसी का reply ये देते हैं paragraph 12 में, that with regard to the statement made by the petitioner in paragraph 10 in the instant writ petition, it is humbly stated and submitted that it is totally false and unauthorized submissions are misleading and are denied, even if no election is held and the member of NAC committee is dissolved, but the committee still remains in legally existence, and ex officio chairman comes sub-divisional officer and its special officer who were authorized to function and carry out the day-to-day work of the notified committee Jamtara, and hence the notice directing payment of holding tax and other tax are legal, authorized in law and valid notice, and the same is within the competence and jurisdiction of the chairman cum SDO Jamtara. तो ये जो इनको ऑथराइज किया गया था वो डे टू डे वर्क करने के लिए किया गया था, ये इन्हीं का स्टेटमेंट है.
You see, neither in your petition nor in the counter affidavit.
वो
There is
स्टेटमेंट हम
a
लोग
clear statement.
हाँ वो क्लियर स्टेटमेंट
It is not there.
हाँ लेकिन
So therefore, even this aspect of the matter will be seen by the appellate authority. जो भी आपका कमिश्नर, आप जाइए वहाँ पे रिव्यू फाइल करिए and then give the date, कब नोटिफाई हुआ, कब क्या हुआ, कब इलेक्शन हुआ. These timelines are completely missing from this. And your insistence that the earlier petition, वो जो द्वारका नाथ प्रसाद वाला है, that is on a different fact, that I can clarify, and then rest will be taken care of the authority before whom we will file your review, the commissioner, who is an authority under the act.
तो इलेक्शन नहीं हुआ पर है
कमिश्नर तो होंगे ना?
नहीं ऑफिसर है, एग्जीक्यूटिव ऑफिसर है.
नहीं है ना भाई, कमिश्नर कौन है इसमें? पेज कौन सा सेक्शन में है बताएं? रिव्यू का पावर 116 तो है ना भाई, उसमें तो कोई डाउट नहीं हो सकता ना किसी को. जिनके पास आप पहले गए थे वही.
पहले तो हम लोग चले गए थे
एसडीओ ही उस समय थे, एसडीओ थे जब.
लेकिन उनको ये अपना ही काउंटर में बोलते हैं कि डे टू डे वर्क के लिए हम लोग किए थे, वो काम करेंगे डे टू डे वर्क के लिए,
कोई भी
लेकिन पॉलिसी डिसीजन जो है
पॉलिसी डिसीजन है ही नहीं.
ये जो आपने डेप्यूटी कमिश्नर के पास फाइल किया था, ये किस प्रोविजन में फाइल किया था? जो इम्प्यूग्न ऑर्डर है, अंडर विच प्रोविजन ऑफ लॉ डिड यू मूव द डेप्यूटी कमिश्नर?
ये लोग तो कोई भी ऑर्डर हुआ एसडीओ का तो उसके ऊपर का सुपीरियर ऑफिसर उसमें वो चले. एक तो एफिडेविट फाइल किया गया इंटरवेनर के थ्रू, ये इंटरवेनर के रूप में आए हैं, इनका एक एफिडेविट फाइल किया गया, कितना तारीख को फाइल किया वो काइंडली देखा जाएगा. ये 3/9/2012 को फाइल.
द सब डिविजनल ऑफिसर कम चेयरमैन
एनएसी नोटिफाइड एरिया कमिटी,
उन्होंने ही ये एनेक्शन 11 पास किया.
करेक्ट.
आप
वही
जाइए
एसडीओ
रिव्यू के पास, रिव्यू के लिए आप
कर
जाइए.
लेते हैं. एक खाली इनका देखा जाएगा एफिडेविट जो ये फाइल किए हैं जामतारा नगर पंचायत.
देखिए, जो चीज फाउंडेशनल फैक्ट आपके रिट में नहीं है तो काउंटर एफिडेविट से आप केस नहीं बना सकते हैं ना. आपका फाउंडेशनल फैक्ट ही नहीं है रिट में कि कब ये नोटिफाइड एरिया बना. Maybe that it was because of the assumption that it is covered by that Dwarka Nath judgment. लेकिन there is a distinguishing fact with regard to Dwarka Nath.
आगे सब्सिक्वेंट कोई बनेगा तो
ये सब्सिक्वेंट तो कोई बनेगा तो ये तो फिर आप इन्हीं के पास जाइए.
खाली
We just
एक
can't
जो ये
decide it.
ये जो फाइल किए हैं उसको खाली हम पढ़ देते हैं, कुछ रेलेवेंट पैराग्राफ. पेज नंबर 10.
Which affidavit?
ये एफिडेविट फाइल हुआ है सितंबर 2012 में, 3
Yes.
सितंबर 2000.
नगर पंचायत.
जी इनके द्वारा. paragraph 12, page number 10, हम onwards 2-3 paragraph पढ़ लेंगे. That it is stated that in the year 2005, the government of Jharkhand has issued a gazette notification whereby and whereunder the Nagar Panchayat has been constituted on 23rd of November 2000. Page 10.
Page 10. Yes, page 10.
Ji. Paragraph 12. That it is submitted that in the year 2005, the government of Jharkhand has issued a gazette notification whereby and whereunder the Nagar Panchayat has been constituted on 23rd of November 2005, and in exercise of power vested under section 390 of the Municipal Act 1922, the manner of imposing tax has also been provided in Rule 3 of such notification dated 23rd of November 2005. The deponent craved to leave to produce the said copy. That it is submitted that by notification number 373 dated 6/2/2006, another notification has been issued whereby the state of Jharkhand has constituted a Nagar Panchayat in Jamtara, which is mentioned at item number 14 of the said notification. Moreover, the rate of tax which has been fixed has also been prescribed by the government. According to their rate, tax has been raised against the petitioner, which is fully justified and proper in the eyes of law. That it is submitted that the power of imposing tax is vested in the government of Jharkhand, and as the answering respondent has stated above, the notification which allows the state government to impose tax and accordingly the tax has also been imposed does not suffer from any of the illegality even after deletion of section 388 of the Bihar Municipal Act 1922. It is stated that from the plain reading of the several provisions of Bihar Municipal Act, which empower state government to impose tax on the commercial use of the property, holding of housing, lighting and using of land for commercial purposes and creating pollution. For these purposes, the state has been empowered to allow the respective municipality, notified area committee, now Nagar Panchayat and other industrial township, whatever may be the name called, with the power to impose tax. So after applying the legal engineering, the tax may not be evaded. That it is stated that in a judgment of AIR 1999 SC 826 that all Nagar Panchayat, Municipal Council and Municipal Corporation comes under the definition of municipality, hence after deletion of section 388 of the Bihar Municipal Act and after 74th Amendment in the Constitution of India as Article 343Q allows for creation and constitution of Nagar Panchayat by the Parliament, which according to the respondent has come into existence on the day of amendment itself. That it is stated that so far as taxing power of the municipality, municipal council and Nagar Panchayats are concerned, all the powers are vested in the Bihar Municipal Act, and even if for transitional period it does not apply in that situation, ये खुद बोलते हैं कि transitional अगर नहीं apply करता है, and even if for transitional period it does not apply, in that situation the tax may be imposed under the Bihar Panchayat Raj Act 1993. According to section 27 of the Bihar Panchayat Raj Act 1993, the present municipality of Jamtara has automatically been provided power to impose tax as they are using the lands for commercial activities. All holdings and lightings provided by the municipality or Nagar Panchayat and the industrial townships where the pollution is made and the commercial activities and business activities are done. तो ये बोलते हैं कि हमको जो पावर है वो पंचायती राज एक्ट 1993 सेक्शन 27
तब पंचायती राज एक्ट में.
हाँ. Paragraph 19 में बोलते हैं, it is stated that for the technical reason if certain officer in the office of the notified area committee was working, although the very existence of notified area committee has come to an end after 74th amendment, even then after enactment of section 390C of the Bihar Municipal Act, the tax already imposed should have been treated the tax imposed by and under the Bihar Panchayati Raj Act 1993 as the said provision as contained in section 390C allows to deal with transitional period.
390C में तो बोल ही रहा है ना, if there is any tax which was imposed prior to that period, prior to coming into force of the ordinance, then that tax has to be realized. Simple. This is the provision. These taxes were imposed prior to coming into force of the Act.
एक सेक्शन 123 2B दिखाना चाहिए.
You see, it also says that if any action has been taken by notified area committee, etc., then shall be deemed to have been taken by municipality or the panchayat, as the case may be, under the provisions of this Act. So there is a clear-cut provision for transition also. Then under such circumstances, whosoever be the authority under this Act.
एक प्रोविजन दिखाएंगे सेक्शन 123.
क्या है 123?
Notice of demand to be presented.
This is on procedural aspect. We are not on.
नहीं वो बहुत important है इसलिए हम पहले दिखा रहे. 123 एक बार kindly देख लीजिएगा.
Yes.
Notice of demand to be presented. Within 14 days of the first day of the quarter, the commissioner shall notify by public proclamation or in such manner as they may consider suitable the date on which an installment of tax becomes due. आगे पढ़ देते हैं. If the sum due on the account of any tax is not paid within 14 days from the date on which it becomes due, the commissioner shall cause to be served on the person liable to pay the same notice in the prescribed form, provided that no notice shall be served more than 6 months after any sum has become due. एक लिमिटेशन दिया गया है कि किस पीरियड का आप हमसे डिमांड कर सकते हैं.
तो ये these are all procedural aspect कि आप किस पीरियड का डिमांड कर सकते हैं. हो सकता है पहले पीरियड का डिमांड पहले से चल रहा हो. We do not know.
नहीं ये तो ऐसे फॉर द फर्स्ट टाइम. ये तो अब जब ये बना साइडिंग ना उसके बाद ये पहली बार जो है ये एनेक्शन 6 इशू करते हैं. उसके पहले हमको हम एक स्टेटमेंट दिए कि इसके पहले हमसे कभी कोई टैक्स लिया नहीं गया था. दैट स्पेसिफिक स्टेटमेंट इज देयर इन द रिपिटिशन.
In the light of this allegation, section 186 may be taken. Notice of intention to erect building or make way. A person shall give notice to the commissioner before beginning with the limits of the municipality to erect a new building or new part of the building, to erect or make a material alteration in the building. ये इनको नोटिस देना. ये आज इवेंट 2024 he has not given notice. What construction he has
तो आपका कहीं स्टैंड नहीं है. लेकिन जो लिमिटेशन इसमें 123 में प्रिस्क्राइब. जी जी
आप लोग दोनों मिलकर कि कौन अथॉरिटीज को देखेगा. बिकॉज देयर आर सो मेनी डिस्प्यूट्स इन्वॉल्व इन दिस केस. ना आपका रिट पिटीशन में कोई क्लैरिटी है. जब आपके रिट पिटीशन में कोई क्लैरिटी नहीं है तो इनके जवाब में क्लैरिटी हम एक्सपेक्ट नहीं करते. आप बताइए हु विल टेक केयर ऑफ इट. हु इज द सक्सेसर इन इंटरेस्ट. अब तो म्युनिसिपैलिटी बन गया.
नगर पंचायत executive officer is the
executive officer who is the successor in interest will take care of everything. आपका ये नोटिफिकेशन नहीं हुआ, ये सब नहीं हुआ, आप जाइए उनके पास.
अभी तो नगर पालिका है, नगर निगम है नहीं, इलेक्शन खत्म हो गया. पीरियड भी 5 वर्ष खत्म हो गया. एक्जीक्यूटिव ऑफिसर है, वही एफिडेविट भी करता है.
he will take care of it. Because these जो आप बोल रहे हैं ना, on the basis of that judgment is clearly distinguishable. So rest of your grievance procedure नहीं follow हुआ. इनका कहना है नोटिस नहीं दिया. फिर आपका कहना है कि नोटिस के पहले आपको कोई अपॉर्चुनिटी नहीं दिया. Everything will be taken care of. And you see, you are a government undertaking.
Yes,
right? अगर 85-86 में आपका एक्विजिशन नहीं हुआ, उसके बाद आपने घर कब बनाया या whatever structure कब बनाया.
हम तो स्पेसिफिक स्टेटमेंट दिए हैं.
आपका स्टेटमेंट यहाँ पे हम असेसमेंट नहीं कर रहे हैं ना. So these things, when it happened, how it happened, this can be taken care of by the executive officer, successor in interest. But you cannot say that you have no liability. ये तो नहीं हो सकता.
नहीं हम तो liability कैसे.
On the basis of liability, the one judgment of this court is गम्हरिया नागरिक समिति 390C is discussed in this case. The same dispute is arose in this case, whether NSC has power or not.
Yes, it's so simple. ये जो बोल रहे हैं यही चीज इसमें बोला same to same. You go before the executive officer. We will say that whatever is your grievance in connection with Annexure 11 or the impugned orders regarding assessment, that will be taken care of. कौन यहाँ एफिडेविट फाइल कर रहे हैं सर? एग्जीक्यूटिव ऑफिसर?
Executive officer है.
एग्जीक्यूटिव ऑफिसर नगर पंचायत जानता. You go before. देखिए, आप गवर्नमेंट है, आपके साथ कुछ ऐसा नाइंसाफी नहीं हो सकता है.
नहीं.
देखिए, ये तो हुआ एक केस का. पहले इसको लिखिए.
वो ये मैडम सारे केस अलग अलग टाइम के
पीरियड
का अंतर है. इनका दो ग्रीवांस था. एक तो आर्बिट्रेरी चार्ज कर रहे हैं और दूसरा मेरे पास राइट नहीं है.
ठीक.
तो हम जो रिटर्न आर्गुमेंट उसको एक बार हम रिकैप्चुलेट कर देते हैं पूरा. जो रिटर्न आर्गुमेंट दिए हुए हैं हम उसमें लेजिस्लेटिव बैकग्राउंड है आर्टिकल 243Q ऑफ द 74th अमेंडमेंट एंड 243X. मेरा ये टाइप ऐसे करते हुए I have quoted that legislative article 243Q and 243X. In the light of 74th amendment, ordinance bring by the Bihar government. In that section, that ordinance, when 288 is deleted, section 390C.
Yes.
That is the saving clause.
You see, just a moment. We can just record his reliance on this judgment of Dwarka Nath Prasad.
Yes.
And then also distinguish the case by saying that in Dwarka Nath Prasad, the notified area notification came later.
Later, and notified area is imposed interest tax. Here I am not imposing any new tax.
Any action.
And then your judgment
Yes.
of Honorable Justice Amreshwar Sahai.
Yes.
Right? And in the present case, we do not have the date on which the notification was issued. By virtue, whether it was issued prior or it was issued after, कुछ नहीं पता चल रहा. कोई डेट नहीं है आपका इसमें.
ये काउंटर एफिडेविट है उसमें एनेक्सर ए है फर्स्ट रीड के साथ पेज 22.
फर्स्ट डीट कौन सा हुआ?
2003 वाला जो अभी जिसमें
2000. काउंटर एफिडेविट का पेज नंबर
22.
काउंटर एफिडेविट का पेज नंबर 22 तो कुछ और ही है.
पहला जो फाइल किया
was taken on 3/9/12.
3/9/12. पेज नंबर 22. हाँ बताइए.
This is the notification.
ये नोटिफिकेशन कब का है? 2006 का है.
Yes.
है ना?
Yes.
और आप जो है नोटिफाइड एरिया की कब की बात कर रहे हैं?
From 92.
92 के पहले कब नोटिफिकेशन हुआ? ये कहाँ से पता चलेगा? नहीं है ना? ठीक है? नहीं है तो फिर उसको क्या ही कर सकते हैं? इन्होंने अपना पूरा ना अपने उसमें इन्होंने अपना पूरा रेट ये एज्यूम करके बनाया है कि एक बार आ गया तो बात खत्म. WPC नंबर 5
पीरियड दिखा दे जो दो खाली पीरियड.
वो मेरे रिटन आर्गुमेंट में
जो 2006 वाला है एप्लीकेशन उसका 3 2004 2004 5 2006
2006 से
2009 वाला 2006
तो अलग ही होगा. क्योंकि ये तो मतलब आफ्टर द कॉन्स्टिट्यूशन ऑफ म्यूनिसिपैलिटी है, क्योंकि
नहीं, लेकिन वो तो वही कर रहे हैं ना।
कर वही रहे हैं।
वही कर रहे हैं, इवन कंस्टिट्यूट भी हो गया तो भी वो कर रहे हैं।
ठीक,
उसको खाली ग्राउंड में ले
ठीक।
पीरियड लिख लिया गया 2006-7 एंड 7-8 2009 वाला।
WPC number 5149 of 2003 with WPC number 1088 of 2006 with WPC number 4503 of 2009. Heard the learned counsel appearing on behalf of the parties. These writ petitions have been filed for the following relief. The learned counsel for the petitioner submits that writ petition number 5149 of 2003 is relating to the period 1992-93 to 2002-3, whereas with petition WP number 1088 of 2006 is relating to the period 2003-4 to 2005-6, and WP 4503 of 2009 is relating to the period 2006-7 to 2008. The arguments have been advanced primarily from the records of WPC number 5149 of 2003. The learned counsel for the petitioner has submitted that the submitted that 36.03 acres of vacant land was acquired for construction of railway siding under Land Acquisition Act by Land Acquisition Case number 5 of 86 and Case number 6 of 86-87, corresponding to notification number 1861 and 1862, both dated 27/9/1991. And it is the specific case of the petitioner that the same was handed over to the petitioner on September 1992. It is further case of the petitioner that a railway siding was constructed sometimes in the year 1996, 1997 and 1998 along with certain structure to facilitate the smooth functioning of the siding/depot for transportation of coal to the core sector of the government. It is further the case of the petitioner that the railway siding in question is of SP Mines Chitra and is situated within Mauza Ghagra number 6 and Mauza Baiba number 8 Jamtada, ward number 3 of the notified area committee Jamtada, and at that point of time the holding number was allotted to the aforesaid area being holding number 284 to the structure constructed at the railway siding at Jamtada by the petitioner. It is further case that The respondents never used to charge any sort of tax from the petitioner with respect to railway siding in question. However, a notice number 7 dated 24/1/2003 was issued for the assessment of annual tax
under section 115(2).
under section
115(2).
Annexure 6.
Annexure 6.
उसमें कोई सेक्शन नहीं लिखा हुआ है.
ऊपर में लिखा हुआ
कहाँ लिखा है? Annexure 6 में.
जी.
अच्छा. Under section 115 within bracket 2 of Bihar and Odisha Municipal Act 1922. And the tax was sought to be levied with retrospective effect from 1985-86. House tax at the rate of 34,575 and lighting tax at the rate of rupees 1,800. The grievance of the petitioner is that the assessment was ex parte and without issuing any notice to the petitioner. It was their further grievance that under no circumstances the amount could be assessed from 85-86 in view of the aforesaid facts. The further grievance of the petitioner is mentioned in paragraph 10 that questioning the jurisdiction of the authority by stating that the notice could not be issued when the present notified committee of Jamtara was not in existence, and at present there is no elected ward commissioner for a long time. It was also submitted that the subdivisional officer, who is the ex officio acting chairman of the notified committee of Jamtara, has no proprietary competence and jurisdiction to assess tax and issue such notice, and as such the entire action was void and nullity in the eyes of law. It was therefore the case that petitioner had filed their representation, but no order was being passed. Under such circumstances, they had moved the Deputy Commissioner in RMP number 1 of 2002-3, who disposed of the matter by order dated 11/3/2003 by observing that a representation was pending before the a representation was pending before the commissioner.
Notified area committee लिखते हैं, NSC लिखते हैं.
Before the notified area committee. The learned counsel submits that ultimately the petitioner approached the notified area committee, and without hearing the petitioner, the order was passed, which is contained in Annexure 11.
जी.
Annexure 11 to the petition.
इसमें additional tax, commercial tax add कर दिया.
In which a few more taxes were also added. Annexure 11 is dated 19/6/2002. 19/6.
हाँ, second page में देखा जो date लिखा हुआ.
Second page में 2006. 19/6/2002. 2002 का है ये order. ये तो 2003 में हुआ. उसके बाद
भाई मैंने रिवाइज्ड है एनेक्सर 25.
Okay. एक second. The learned counsel has submitted that thereafter the revised demand was issued by the Annexure 25, dated
टाइप का डेट है
12/9/3
12/9/2003. The Learned Counsel submits that the authorities have been issuing the orders without granting opportunity of hearing.
Ma'am, revised demand is 5/9/3.
5/9/2003.
हाँ, it was received on 12/9/3 by the CM.
5/9, ठीक है?
Yes, 5/9/3.
The Learned Counsel submits that the revised demand dated 5/9/2003 and other orders are also under challenge before this court. He has also referred to supplementary affidavit by raising a grievance that the representation of the petitioner was not disposed of after granting any opportunity of hearing, and a specific statement has been made in the supplementary affidavit that the notified area committee was no longer in existence in view of the ordinance number 13 of 1954 introduced with effect from 30/5/1994.
एक बार फैक्ट बता देते हैं ये लोग सर्टिफिकेट केस भी कर लिए दैट इज एनेक्शर 21, 22 एंड 23 उसमें भी वही एसडीओ साहब का ही सिग्नेचर है.
The Learned Counsel has also submitted that certificate case was also filed for realization of dues
by the same officer. He
by
is,
the same officer, which is, and the certificate proceedings which is apparent from Annexure 21,
22 and 23.
and 23.
इसमें कोई सर्टिफिकेट भी नहीं दिया दैट अमाउंट इज ड्यू तो रिक्वायरमेंट है वो नहीं और ही कैन नॉट बी जज इन हिज ओन कॉज.
डेट भी नहीं है,
डेट भी नहीं है कोई नंबर भी नहीं है कुछ नहीं बस एक हम लोग को भेज दिया और हम लोग सब्सिक्वेंटली 50% अमाउंट डिपॉजिट कर दिए हैं एज पर द डायरेक्शन ऑफ ऑनरेबल दैट इज ऑर्डर डेटेड 18/10/2003
The Council has submitted that the petitioner has already deposited 50%.
50% या
ये तो देखिए डायरेक्शन
पक्का नहीं मालूम को 50% है क्या पर 5 लाख जमा कर
जो भी कोई अमाउंट
Certificate
has
depositing
deposited
state
18/10/2003 के बाद में हम लोग कर दिए थे
by
जमा किया हुआ है और वो सर्टिफिकेट
has
प्रोसीडिंग
deposited certain amount
pursuant to order dated 18/10/2003.
pursuant to order dated 18/10/2003.
जी.
By the order dated 18/10/23, the petition it was observed that if the petitioner deposits 50% of the assessed amount within 1 month, the respondent shall not take any coercive steps against the petitioner.
ये
The
सब
just
इसके बारे में बोल दीजिएगा कि हम इसमें कोई डेट भी नहीं मेंशन है कुछ नहीं है कोई केस नंबर भी नहीं है एंड ही
The
इट हैज बीन
Learned Counsel
इशूड बाय द
appearing
सेम ऑफिसर
on behalf of the petitioner has relied upon the judgment passed by Hon'ble Patna High Court, Ranchi bench, no, Hon'ble Patna High Court, in the case of Dwarka Nath Prasad versus State of Bihar, reported in 1999 bracket close PLJR, volume 3 PLJR 718. Equivalent is 1999 SCC online Patna 854, and has submitted that
For judgment.
after the 74th Amendment of the Constitution of India, Bihar Municipal within bracket Amendment bracket close Ordinance 1994 was introduced with effect from 30/5/1994, and the provision of section 388 was deleted from the statute book, and therefore the notified area committee ceased to exist, and consequently no proceeding for of whatsoever nature could have been initiated to recover any amount from the petitioner by the authority under the notified area committee.
For judgment जो division bench का दिया है.
He has also relied upon the judgment passed by
Division bench. In the case of Ram Naresh Singh versus State of Bihar.
Honorable Division Bench of Patna High Court in reported in 2000 within bracket 3 bracket PLJR 736, and has submitted that the Division Bench has also taken note of the judgment passed in the case of Dwarka Nath Prasad versus State of Bihar Supra, and has observed that the subdivisional officer in the capacity of chairman of notified area committee could not have settled a piece of land as taxes stand and prescribed for collection of tax. He submits that the said judgment was passed in view of the 74th constitutional amendment deleting section 388 of Bihar and Orissa Municipal Act. However, during the course of arguments and from the writ petition, it is not clear as since when the notified area committee Jamtara was in existence, whether it was in existence prior to coming into force of the 74th constitutional amendment followed by Bihar amendment, that is 35/1994 or thereafter. This or it was constituted thereafter. This fact assumes importance in view of the fact that in the judgment of Dwarka Nath Prasad Supra, the concerned notified area committee was notified by the state government after coming into force of 74th constitutional amendment followed by Bihar Municipal Amendment Ordinance 1994, which was introduced with effect from 30/5/1994, and the connected notification with respect to notified area committee was dated 1914/7/1994/19/7/1994. The learned counsel appearing on behalf of the respondents by opposing the prayer has submitted that the taxes which were imposed prior to coming into force of Bihar Municipal Amendment Ordinance 1994 were made effective from 30/5/1994 was realizable, and the notified area committee which was in existence on 30/5/1994 continued to operate by virtue of section
91.
390
C.
capital C of Bihar Municipal Act 1922. He has submitted that merely by virtue of the aforesaid notification or aforesaid Bihar amendment made effective from 30/4/1994, the liability created under the then existing law is not wiped out. However, during the course of argument, the learned counsel has not been able to give any date and also could not clarify the fact from the records as to when the notified area committee Jamtara was created. Thus, neither in the writ petition nor in the counter affidavit, this fact has been placed on record. The learned counsel has further submitted that by virtue of the transitional provision, the grievance of the petitioner in connection with the quantification of the taxes can be taken care of by the executive officer of Jamtara municipality of Nagar Panchayat, as the Nagar Panchayat has been constituted by virtue of notification dated लिखे है ना अब इसमें notification dated 23/11/2005 correct 23/11/2005
Yes.
the learned counsel has also submitted that the connected notification creating Nagar Panchayat has been placed on record
Page 22 of the contract.
in the counter affidavit dated 3/9/2012 which is at annexure A. ये तो notification है आपका 6 February 2006
Yes, yes.
हाँ इसका डेट ठीक करेंगे Wide notification dated 6 February 2006. The learned counsel has submitted that in the batch of writ petitions, certain period is post 6th of February 2006. The grievance in connection with the period after constitution of Jamtara Panchayat can also be taken care of by the executive officer. He has submitted that if any liability has been imposed under the prior act and the notified area committee was in existence prior to Bihar amendment, then under such circumstances, the liability would remain and it will be, and if there is any subsequent notification under the act creating any liability by virtue of creation of Jamtara Panchayat, the same can also be taken care of. The petitioner, being a government undertaking, can certainly place the entire material before the executive officer of Jamtara Nagar Panchayat.
My lord, two provision 186 and 150A. 186 shows how much construction is made, and 150A shows what is the income, because I am imposing commercial tax.
Just a moment. in terms of the provisions of the Municipal Act. बस इतना ही लिखा
हाँ,
है और क्या ही लिखा है
ना ठीक है
ठीक है The Learned Counsel has submitted that in the affidavit dated 5/9/2012, specific reference has been made in paragraph 18 with respect to the saving clause under section 390 capital C
yes
of the Municipal Act.
ma'am
And-
case may be noted my case Gamaya
Yes,
Analysis.
the Learned Counsel has also relied upon a judgment passed by this court reported in 2004 within bracket 3 bracket close JCR 26204 and has submitted that by referring to the provisions of section 390 capital C of Bihar Municipal Act, this court has observed that the main section envisages that municipality and notified area committee shall cease to exist after commencement of ordinance, but the second proviso saves the existence of municipalities / notified area committees till regular municipalities / notified area committees are constituted. After hearing the Learned Counsels appearing on behalf of the parties and considering the facts and circumstances of this case, this court finds that the foundational fact with regard to acquisition of land for the purposes of railway siding is not in dispute. The notification, the land acquisition notification is the corresponding land acquisition case is land acquisition case number 5 of 86 and case number 6 of 86-87. Apparently, numerous orders have been passed in the present case relating to quantification of taxes by the notified area committee. However, the exact date of constitution of notified area committee Jamtara is not on record. The petitioner has relied upon the judgment passed in the case of Dwarka Nath Prasad Sutta, wherein the notified area committee itself was constituted after the coming into force of Bihar Municipal Amendment Ordinance 1994, which came into effect from 30/5/1994. And accordingly, all the action taken by the notified committee constituted after 30/5/1994 was vitiated. On the other hand, the respondent has relied upon the judgment passed in the case of Gamaria Nagrik Samiti versus State of Bihar, which refers to Section 390C of the Municipal Act, whereby there is a saving clause and continuity has been taken care of. The grievance of the petitioner in connection with the liability, both with respect of the quantification and the liability under the Act pre-amendment, will essentially is required to be taken care of by taking into consideration as to whether the Jamtara municipality Jamtara Notified Area Committee was in existence prior to 30/5/1994 or it came into existence thereafter. Correct?
I know one thing. There is some state government notification after the amendment.
Okay. And other government notifications issued thereafter.
Yes.
In absence of the exact date of coming into force of Jamtara Notified Area Committee, the point raised by the petitioner that the entire liability is null and void cannot be decided in the state proceedings. The fact also remains that the liability has been fastened upon the petitioner without giving opportunity of hearing, and therefore the petitioner is also aggrieved by the quantum of liability. In such circumstances, this court is of the view that the executive officer of Jamtara Nagar Panchayat Jamtara would be the competent authority to consider the grievance of the petitioner with respect to his liability prior to the coming into force, prior to 35/1994, and also post 35/1994, and also pursuant to creation of Nagar Panchayat, Jamtara Nagar Panchayat in the year 2006. Certain liability involved in the present case is also for the period post 2006. The matter, accordingly, the executive officer
Yes.
of Jamtara municipality
Nagar
Panchayat is directed to look into the grievance of the petitioner in the light of the aforesaid observations made by this court, and upon filing of a representation with respect to liability of each period. Within a period of 3 months from the date of filing of such representation, it is observed that the date of notification of Jamtara Notified Area Committee will have a special bearing in the case, and therefore the order should clearly reflect the date of notification of Jamtara Notified Area Committee.
Section 1.
The petitioners to produce the records of this case along with the judgments which has been cited by them.
सेक्शन 123 के बारे में जो मेरा सबमिशन था, प्रोवाइजो में नो नोटिस शैल बी सर्व्ड मोर देन 6
That I have
months,
said,
वो उसके बारे में
all points left.
123 के बारे में स्पेसिफिक दे दिया
All points.
बिकॉज अनेक्शर 14 और 19 जो इशू हुआ था वो सेक्शन
ऊपर
123
लिखिएगा.
जी
The counsel for the petitioner has also submitted that the notice of demand was issued beyond the prescribed period of limitation provided under section 123
proviso A.
proviso
A.
Under section 123 of the Bihar and Odisha Municipal Act.
The reason is he has not complied section 186.
The counsel for the respondent has submitted that the petitioner has not complied the provisions of section 186 and at no point of time notice was given to the notified area committee regarding erection or construction of the
And
building.
about the transaction of the commercial.
That's it.
regarding transaction
186 में ना?
186 में एरिया देना है, 150
in
A में
terms of-
कमर्शियल ट्रांजैक्शन का भी ये देना
In
है,
terms of section 186 and
150 A.
150 capital A?
A, yes.
Capital A of Bihar and Odisha Municipal.
हम कब से कमर्शियल ट्रांजैक्शन किए हैं वो अनेक्शर 1 से 4 है
तो वो आ जाएगा, तो दे देंगे तो हो जाएगा.
जो क्रूशियल डेट है वही नहीं है इसमें, तो क्या ही करेंगे.
regarding
Yeah,
certificate
the
case
payment, एक second, the payment made by the petitioner would be subject to the final result.
और अभी जो सर्टिफिकेट केस चल रहा है जो कि
इसका क्या ही करेंगे? Would be the final, subject to the final outcome of the representation to be filed. आपको hearing चाहिए, date चाहिए, क्या क्या चाहिए, सब मिलेगा आपको order. ठीक है? You will get a date for appearance, you will get the right of hearing, ये सब चाहिए. the authority to pass order without being influenced by any of the orders.
तो अभी तक जो डिमांड है वो तो खत्म हो जाना चाहिए। अगर हम जा रहे हैं तो फ्रेश वो ऑर्डर पास करें।
फ्रेश करेंगे,
तो ये क्वाश हो जाना चाहिए जो अभी का डिमांड है।
ऐसे नहीं होता है।
Password is from supplementary list item 1, WPC 5501 of 2015.
Yes. Nobody appears. आपका एक केस है मिस्टर, वो अपीयर कर रहे हैं, आपका काउंटर भी नहीं फाइल हुआ उसमें, सर्टिफिकेट प्रोसीडिंग स्टेड है यहाँ से, आप जरा देखिए, यू डू समथिंग अबाउट इट, जस्ट अ मोमेंट प्लीज। द लर्नेड काउंसिल फॉर द, आप लेंगे JUPNL,
मैं सीख का काउंसिल परमिशन टू रिकंस्ट्रक्ट द फाइल,
आई गिव यू एवरीथिंग, बस अगला डेट में टाइम मत मांगिए। आइटम 6, ठीक है, इसमें आपको सब्स्टिट्यूशन कौन फाइल करेगा, आप करेंगे?
To file for JCB to JPB.
The learned counsel for the parties are present. From the records of this case, it appears that no counter affidavit has been filed. Have you also checked it?
Manoj?
Have you checked it?
Yes, Manoj. Not
No counter affidavit has been filed. The counsel for the petitioner has submitted that the respondent board is no longer in existence. He shall file appropriate petition. ऐसे कर रहे हैं?
यस
बताइए कौन सा अथॉरिटी होगी?
झारखंड ऊर्जा विकास निगम थ्रू चेयरमैन का मैनेजिंग डायरेक्टर।
लिख के। At this, Mr. M.K. Roy submits that the successor in interest is Jharkhand Urja Vikas Nigam Limited through its chairman having his office at Jara de de. Engineers Building, Durba Ranchi. Counsel for the petitioner is directed to add the aforesaid authority as respondent number 5. Counsel for the newly added respondent prays for time to file a counter affidavit in this case. How much time will you need?
3 weeks
3 weeks time दे दीजिएगा इनको. Rejoinder if any by next 4 weeks. Pose this case for final disposal on February 13th? No, 13th February नहीं हो पाएगा. On 24th February, on 24th of February 2025. At this, counsel for the parties have submitted that they will have to reconstruct the records. Office is directed to provide a soft copy of the entire records of this case to the parties at the following email ID. आप अपना मेल आईडी देंगे?
and my name may be shown in the list now, so that
आप वकालतनामा आपको फाइल करना पड़ता है ना, ये कर दीजिए.
Password case item 1.
Yes.
Your Ladyship, we are challenging Anubha 5, by which our application under Order 1 Rule 10 has been dismissed for impediment of. It's an intervention application.
That's right. You are the successor in interest. Bought the property after decree.
After decree and during the pendency of the execution proceeding, and thereafter the judgment debtor had filed an application under
For setting aside
the ex parte order.
Nobody appears for the respondents.
Because on the last occasion they appeared, but they said that the client has taken back the file.
Today also they said the same. WPC number 5501
The
of
Ladyship has pointed out one judgment on the last occasion.
Yes, could you get that?
Your Ladyship, I will just point out one thing. The execution case has been disposed of in this particular case. Uncontested disposed of. This is what the status is. We tried reaching out to the client.
No, but they are seeking setting aside
setting
ex parte
aside. That is
judgment.
altogether a very different proceeding.
They're very different proceeding. Which is paragraph? Which is that paragraph?
Paragraph 9. From last 5th line, it would be relevant. May I?
This is regarding pendency of suit, right?
And
You are
there
seeking intervention post disposal.
Post disposal, but we purchased the property during the execution proceeding. Therefore, the principle of lis pendens would apply.
You have referred to Order 21, Rule 16
Order 21, Rule 16.
in your petition.
We have referred to Order 22, Rule 10 in Para 16.
Order
22, Rule 10.
21, Order 22, Rule 10.
Para 16 of our application may be seen.
Yes, Order 22, Rule 10. This judgment is also Order 22, Rule 10. Yes, Order 22, the transfer list pendency in case of any assignment or creation of any interest during pendency of suit. This one. Order 21, Rule 16 you have referred. Para number 8.
In para 16, Order 22, Rule 10, in this particular paragraph, in para 16.
No, in your writ petition you have referred to Order 21, Rule 16. Isn't it?
In para 16, you have already said.
Para 8 आपको दिख रहा आपने petition का? ये petition वहाँ फाइल किए थे कि कहाँ फाइल किए थे? No, you filed it over there, perhaps. This is page number 37. You relied upon this provision, Order 21, Rule 16. Correct? You relied upon that provision, isn't it?
Yes, we did the
कोई बात नहीं,
But in
आपकी और
para
है।
10 of para 16 of our writ application, we have mentioned the provision of Order 22, Rule 10.
That is applicable when the suit is pending. Here is a petition where you are seeking intervention when the suit is disposed of, isn't it? Correct or not correct?
Correct.
बताइए क्या बोल रहे हैं? हम तो आपके लिए जजमेंट लेके आए हैं, देखते हैं आप क्या बोलते हैं.
Now, because my argument would be that my vendor has transferred his all rights to me. Now, in this particular application for setting aside the ex parte decree, when he is not contesting then I should be permitted to contest in that particular application because now I have stepped into his shoes and therefore my right is involved. So I am claiming through him validation. So because he is not contesting in that particular proceeding, I may be allowed to contest.
The court says that this provision will not apply because of the reason that the suit is not pending. What do you have to say to that?
Now kindly have, if I may permitted to read out section 146 of CPC.
What is it?
It says that save and otherwise provided by this court or by any law for the time being in force, where any proceeding may be taken or application made by or against any person, then the proceeding may be taken or the application may be made by or against any person claiming under him. Now in this particular proceeding, Your Ladyship, I am claiming under him, my vendor. Therefore, I should be given an opportunity to contest.
Okay. Correct. Judgment नहीं खुल पाए, हम लेके आए. WPC number 5501 of 2015. Counsel for the petitioner is present. When the case was taken up on 13/12/2024, the counsel for the respondent, under instructions of Mr. Abhay Prakash, advocate on record on behalf of the respondents, had submitted that the client has taken brief from him and he has no instructions. Today nobody is appearing on behalf of the respondents. This writ petition has been filed challenging the order dated 14/7/2015 passed by learned Judicial Magistrate cum Additional Munsif Roman 9 Ranchi, whereby the learned court has dismissed the petition seeking intervention dated 27/10/2015 filed by the petitioner under Order 1 Rule 10 of CPC for being impleaded as opposite party to the miscellaneous case. The learned counsel for the petitioner has submitted that a suit was decreed being title suit number
Title suit number 41 of 2000.
being title suit number 41 of 2000 against the respondent number 1 herein, and it was decreed in favor of the decree holder, namely Dr. Javed Ahmed, on 12/1/2004. Execution case was filed. It was registered as execution case number 4 of 2010. And in the meantime, by registered deed of sale dated 3/4/2013, said Dr. Javed Ahmed transferred right title and interest over the suit property in favor of the petitioner. He has submitted that in the month of, he has submitted that after the property was purchased by the petitioner, a miscellaneous case number 3 of 2014 was filed by the respondent herein for setting aside the ex parte decree dated 12/1/2004 passed in eviction title suit number 41 of 2000. He submits that the decree holder, having sold the property in favor of the petitioner, has not been taking any interest and did not even appear in the proceedings to contest. The petitioner, under such circumstances, being successor in interest of the decree holder, filed the petition under Order 1 Rule 10 of CPC, but the same has been dismissed by the impugned order dated 14/7/2015 by observing that if the ex parte decree is set aside, then the petitioner would have a right to contest the suit once again. The learned counsel has referred to the provision of Order 21 Rule 16 CPC and also Section 146 of CPC to submit that the transferee in interest has a right to contest the matter. The Learned Counsel has submitted that the right stood crystallized in favor of the decree holder and the decree attained finality and therefore the petition seeking setting aside of ex parte decree, if allowed, will prejudice the case of the petitioner. He has submitted that he has right to contest not only the petition setting aside ex parte decree, and if that is allowed, then he would certainly contest as a party in the suit. The Learned Counsel submits that this aspect of the matter has not been properly considered and therefore the impugned order be set aside. He has submitted that the execution case has been closed but the same has no bearing as because if the impugned order is set aside then the suit would be violated. After hearing the counsel for the petitioner and having gone through the impugned order, this court is of the view that the petitioner being the successor in interest of the property which was sold by the decree holder in favor of the petitioner has an interest involved in the matter. The law is well settled that even a successor in interest has a right to file execution case by virtue of Order 21 Rule 16 of CPC and Section 146 of CPC clearly provides that a transferee in property has a right. This court is of the view that setting aside ex parte decree by itself requires adjudication, and the decree holder having sold the property does not have any surviving interest in the proceeding. In such circumstances, the petitioner certainly had a right to contest the same, and the proceedings will certainly be decided on the basis of the materials in the suit. There could be other related issues involved in the matter. This court finds that the right of the petitioner being successor in interest from the decree holder has been adversely affected, can be adversely affected if the decree itself is set aside. Therefore, the impugned order dated 14/7/2015 calls for interference under Article 227 of the Constitution of India, which is hereby set aside. That should be sufficient. This repetition is accordingly allowed. That MA is pending, I suppose.
MA is pending, but
the petitioner has submitted that so far as the miscellaneous application is concerned, that the same is pending. Communications. एक केरला का जजमेंट मिला है, एक चलिए I'll just I've not read it actually. I just got the judgment and got a print, and I'll just go through it and then inform you.
Item 4 from the list WPC 4123 of 2008.
Yes, Krishna.
In this case, the petitioner will not a challenge that the order of the SAR court where the case has been had to be maintained. The SAR case, it was earlier filed, earlier dismissed, 144 dismissed, everything was decided. Again, he had filed the same case for the same subject matter, changing his brother as a party, and that the court has said that is maintained.
Changing the brother as a party.
The petition now in the second litigation, his brother has made the party. The plaintiff.
Brother is the applicant.
Brother was yes, the applicant, and therefore the court has held the case maintainable. Although everything was decided for the same piece of land, everything was decided. The proceeding was dropped.
Now
144 was also dropped.
The brother has come.
The brother has.
Brother is the applicant, or he is applicant with both the brothers are applicant. Only one brother is applicant, or both brothers are applicant. Yes.
I'm just saying. Only one brother.
So the
brother
comes up.
The piece of land is same.
Piece of land is same. So.
And that was decided.
That will be binding on the brother.
For the same piece of land,
कोई law बताइए brother के ऊपर binding हो जाएगा.
ये तो change करके just
change मतलब भाई नहीं है वो.
For everyone, for the piece of land, it was held that it was purchased. They are in possession since long back.
law बताइए ऐसे नहीं. आप बोलते हैं भाई के ऊपर binding नहीं है, कोई law बताइए. Res judicata on the brother.
Not for the same piece of land.
Same res judicata के लिए क्या requirement है?
A constructive res judicata.
How constructive res judicata?
It goes to the root of the case.
No. How constructive res judicata will apply? Parties are not the same.
The property
दोनों भाई same हो जाएगा.
The property is same.
Property is same. एक
property. And it was held that the property.
थोड़ा law बताइए ना res judicata.
Constructive res judicata.
पढ़िए जरा भाई CPC दीजिए उनको CPC पढ़िए. Between the same parties. Between the same parties.
It is one of the.
Then one of the that is the basic ingredient.
Therefore, we will have to find an IA annexing the copy whereby the court has annexing the order.
Have any bearing.
Whereby the court has held that it is maintainable. Earlier, the court has said that it is not maintainable. Drop the proceeding. The same court has said that now it is maintainable.
Maintainable, it was not maintainable at the instance of somebody else. And ultimately, on merit, it decided that it is whatever, the relief was not granted. आपको जो करना है अपना maintainable है आप जाके वहाँ पर.
Can I submit? Subject matter of the land is plot number 924.
Yes.
Of Khata 80. The total area of the land is 12 decimals.
80. 12 decimals.
12 decimals. Now, by a registered sale deed, the sons of the recorded tenant, sale deed dated is 4/7/1992. This is annexure 1. 6.5 decimals was transferred to the petitioner. My lords will kindly see the schedule, which is given at page 19. So 6.5 decimals out of 12 was transferred by way of a registered sale deed. The earlier proceeding and the proceedings under 144 related 144 and the earlier 71A related to that 6.5 decimals. Now what the petitioner has done, he has got his name mutated in respect of 12 decimals, and that is why the present proceeding under 71A. It is very evident from the annexures. Madam, kindly see page 19, the schedule of the sale deed.
No, that's right. It is with respect to the same property.
Yes.
Correct?
I mean,
it is with respect to the same property.
No, 6.5 decimals was transferred, and the earlier proceeding was in respect of 6.5.
Okay.
And now now I will see the application under 71A. It is in respect of 5.5 decimals. The remaining 5.5 which was not transferred, but he has taken possession. Petitioner has taken possession.
Okay. So the description of land is also not the same.
Not same.
Some additional land now is claiming.
आप अभी तो बोले same property.
नहीं उस प्रॉपर्टी को तो ले ही रहे एक और प्रॉपर्टी जोड़
No,
दिया।
no, no, no. So हम दिखा
नहीं it is in relation now. Earlier property is also involved.
सबसे बड़ा बात है same party नहीं है।
हाँ।
तो इसलिए रेस जुडिकाटा का बात नहीं है, आप जाके कंटेस्ट करिए।
हाँ ठीक।
ऐसे नहीं। कहाँ है ये? You proceed. Who is for the state?
My lord may indicate that he is right, that there he will raise the point of maintainability.
No, why?
Maintainability has already been decided.
Maintainability has already been decided. We will uphold this order. This petition was filed by whom? Annexure 8, right? Is under challenge. Okay. 21/6/2008. Yes. This was filed by whom?
The respondent numbers, private respondent numbers, 5 and 6.
5 and 6. Okay. Earlier petition was filed by whom?
Suraj Munda division. He was the brother of Jharkhand.
बस वही किया ब्रदर चेंज कर दिए the property is also involved.
Property involved is not the same.
The earlier property is also the subject matter of this case.
Where is the order passed in the earlier case?
My lord. Sorry.
That may not be in fact relevant also. Parties are not the same. We will not say anything more.
The annexure 6, my lord. Page 32.
My lord find that is in respect of 2 katthas. So 2 katthas is more or less.
12 katta. 12 katta.
5.5 acre. Dismal. 5.5 dismal. Right?
Let's page 34 below. The
Annexure 9. It is the with respect to the previous order. इसका बताइए property किसका है?
Annexure 9 is the order whereby the court has held the case is maintainable. That I have annexed.
No. There is one IA or
yes,
whatever.
that IA I am talking about.
Yes, that IA.
Yes, it is.
Yes. गवाही देना.
But that IA will not perhaps it got dismissed. It is not in force.
This is 155 of 2008-9, right?
Yes.
Yes.
This is in relation to 5.5
5.5.
It is mentioned in the order only. Isn't it? Where is the previous order?
No, annexure 6.
Annexure 6.
Page 32.
What is the area of this property? दो कट्ठा
नहीं 12 होना चाहिए
12 कहाँ से
12 कट्ठा है इधर मिलर annexure 1 मिलर can you see the sale deed the mutation paper everything is part 12 dismissed
Can you see the sale deed?
mutation mineral में can you see annexure page
ये वो सब हम लोग नहीं देखेंगे ना prima facie parties are not the same
of course the parties are not same but the suit property is involved
we will see there is a dispute whether the properties are same or not that I will observe okay. Heard the learned counsel appearing on behalf of the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner submits that the SAR case number 155 of 2008-9, which has been initiated in connection with khata number 80, plot number 924, area 5.5 kattha.
Decimal.
5.5 decimal. Under Thana number 192 district Ranchi is barred by res judicata inasmuch as the brother of the applicant, namely Suraj Munda, had filed earlier petition for restoration of land and the same was dismissed. He submits that now his
It is
brothers have come up to claim the property.
6.05 decimal.
Now his brothers have come to claim the property.
6.05 decimal.
किसमें?
इसी में.
इसमें ऑर्डर में तो जो लिखा है वही ना
नहीं, यहाँ
देखेंगे?
लिखा हुआ है.
5.5 कट्ठा?
It for which he is claiming.
That's right.
My
Previous was 6.0.
6.0.
The learned counsel appearing on behalf of the private respondents.
Yes.
Private respondents has opposed the prayer and has submitted that the parties are not the same and therefore it cannot be said to be barred by res judicata. Apart from that, he has submitted that the earlier proceeding was in relation to another portion and the total area involved in the said property was
In the earlier proceeding, 6.05.
6.05 decimal and the total area of the plot was 12 decimal. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, there is a dispute as to whether the proceeding involved in the present case is with respect to the same property which was involved in the previous proceedings, and admittedly the petitioner, admittedly the previous proceeding was initiated by the brother of the private respondents, and the private respondents were not party in the said proceedings. Correct? In such circumstances, this court finds no reason to interfere with the impugned order dated 21/6/2008, wherein the proceeding has been held to be maintained. This writ petition has remained pending before this court since 2008. The SAR officer is directed to expeditiously dispose of the SAR proceedings. The parties to cooperate. Impugned order, if any, stands submitted.
Can you indicate the rent receipts will not, they are also in my favor.
वो आपको जो करना है वही करो.
After hearing the parties, at least will.
आपको हियरिंग क्या? कौन सा दिन अपीयर करेंगे? बताइए ना, यही से डेट
पड़ेगा.
बताइए. डेट यहीं से पड़ेगी. बताइए SAR ऑफिसर आप हैं? डेट फिक्स कर देते हैं. चलिए.
नोटिस कर रहे हैं पार्टीज.
कुछ नहीं, नोटिस पे लोग अपीयर नहीं होते हैं.
नहीं होंगे.
नहीं होते हैं. पार्टीज
On
के
that
अपीयर.
notice भी my client is also not in contact with me. ये DFD हो गया था केस. तो फाइल लेके चल गए. फिर बाद में बिना नोटिस के रेस्टोर हो गया.
ठीक.
Leadership in serial 5 we are praying for an adjournment today.
5 is what?
So it's a leadership, it's a batch matter.
Adjournment for what? Who are you?
Leadership, I'm appealing on behalf of the state.
State अभी पिटिशनर का आता ही पता नहीं है वो कितना टाइम
Petition.
कुछ भी नहीं है आपके केस में. आप ऐसे नहीं करिए. कुछ मैटर्स में तो इम्प्यूग्ड ऑर्डर भी नहीं. करेक्ट?
नहीं, इम्प्यूग्ड ऑर्डर है सबमिटेड. ये तो जिसमें पास किए हैं वो है बाद में.
हाँ, जिसमें नहीं पास किए हैं उसमें तो नहीं है.
हाँ, नहीं.
या है ही नहीं और यही नहीं पता पास किए हैं कि नहीं. लाए हैं आप लिस्ट?
नहीं, लिस्ट ऑफ डेट्स हम बनाए हैं, बट माय आल्सो सबमिशन इज that this similar matter is pending before the division bench, and I'll just pass it on because my colleague had made this submission earlier. This is the matter which is pending before the full.
Yes, we are aware of that.
Yes.
Some of the matters we have disposed of irrespective of that pendency.
Correct.
Now you have filed an appeal and you have got your matters attached with that.
Yes, that is also the order. But my lord, I just want to, Her Ladyship, I just want to say one thing. My lord, the litigant before this court is same. My lord, whether it's a state or the petitioner. My lord, in circumstances where the petitioner is before your lord, my lord, the private individual are there. My lord, then the matters would be decided irrespective of the division bench orders pending or full bench. When it comes to the state.
You see, we'll take it up in 2:15. We are on the verge of rising right now. We have to see individual cases. The reason being that there could be multiple reasons for rejection, isn't it? Limitation may not be the only reason, and
that is true
in some of the cases there is no impugned order. So we will just observe that if any order has not been passed, the same be passed. such that the entire stand of the respondent should come in the order, and then you can have your fresh right to challenge it. And in those cases where order has been passed, we shall see, so there will be a separate kind of an order in those matters.
I will only say, my lord, that her ladyship is being regularly following this principle. When the matters are before the divi, then your ladyship are adjourning it, awaiting the outcome of the division.
We will see that. We'll see that.
Well, I'll only
We'll see that. You just come at 2:15 and find it out in how many cases there is no impugned order.
Yes, that we have made the list.
How many of them are there? Where there is no impugned order?
I'll check it
आते हैं
again.
2:15
2:15 बजे.
आपको टाइम का कोई जरूरत नहीं है. कौन है आपके सीनियर टाइम लेने के लिए भेज देते हैं?
Ladyship, the Advocate General is away due to ill health. Also, we need time to reconstruct the
वो आपकी जरूरत नहीं पड़ेगी.